Unit 6. The Law of Agency. Learning Objectives. When you have completed this unit, you will be able to define the agency relationship and the parties to an agency.
A. Distinguish the employee from the independent contractor. A. Describe a single agency and dual agency. A. Identify the ways in which an agency relationship can be created. A. List the types of listing agreements and describe them. A. Describe the contents of a typical residential listing agreement and buyer-broker agreement. A. List the rights and duties of principal and agent. A. Explain the contents of the real estate transfer disclosure statement and the agent's inspection disclosure. And A. Recognize the ways in which an agency relationship may be terminated. California_E_principles_10E_book.int 127 the 23rd of May 2017 2:26 and 52 seconds p.m. 128 California Real Estate Principles 10th edition. Key terms: accounting, actual authority, agency, agency confirmation form, agency disclosure form, agent, apparent authority, associate licensee, attorney-in-fact, bilateral contract, commingling, compensation, confidentiality, conflict of interest, cooperating brokers, cooperating split, dual agency, due diligence, duty of care, employee, employer, equal dignities rule, estoppel, exclusive agency listing, exclusive authorization, and right to sell, listing, express agreement, fiduciary, full disclosure of, material facts, general agent, general power of, attorney, good faith and honesty, implied agency, independent contractor, inherent authority, loyalty, multiple listing clause, multiple listing service, MLS, net listing, obedience, open listing, option listing, ostensible agency, pocket listing, power of attorney, principal, procuring cause, prospective economic advantage, ratification, recovery account, safety clause, secret profit, single agency, special agent, special power of attorney, subagent, unilateral contract. Summary: the agency relationship establishes the authority of the agent as a special agent or general agent to act on behalf of a principal in dealing with third parties. A real estate listing agreement authorizes a broker to receive a deposit on behalf of the seller, market the property, and authorize payment to cooperating brokers. The multiple listing service, MLS, is an association of real estate agents who place properties listed for sale in a network that may be accessed by other MLS members. A seller may make an offer of subagency through the MLS. An agent may be an employee or an independent contractor. The California real estate law will always treat a salesperson or another associate licensee as an employee of a broker in considering the associate's rights and responsibilities to buyers, sellers, and other parties to a real estate transaction. A dual agent serves both buyer and seller in the same transaction. All transactions of residential properties of up to 4 units require written disclosure of the agent's representation. A power of attorney granted to an attorney-in-fact will enable that person to act in the capacity of the principal. An agency may be established by express agreement. A principal may ratify conduct that establishes an agency, or an ostensible implied agency could be formed by estoppel. A contract between broker and salesperson must have the same formalities as any contract, including consideration by both parties. An agent's authority may be actual, inherent, or apparent. If a real estate licensee receives funds on behalf of client or customer, those funds must not be commingled with the licensee's own funds. California_E_principles_10E_book.int 168 the 23rd of May 2017 2:27 and 14 seconds p.m. Unit 6 The Law of Agency 169 Listing agreements, which must be written, establish the agency relationship of real estate broker and client. The parties may agree to an open, non-exclusive listing, an exclusive agency listing, an exclusive authorization and right to sell listing, which may have a multiple listing clause, a net listing, or an option listing. Buyer-broker agreements, which must also be written, provide important benefits and protections for property buyers through representation by their own real estate broker. The real estate agent owes the duties of a fiduciary to the principal, Whether a buyer or seller, the agent must reveal any possible conflict of interest and may not make a secret profit. The real estate agent's main task in listing property for sale is to find a ready, willing, and able buyer. The principal must pay the agreed-on compensation if the agent fulfills the agreement. In a real estate transaction, that means that the agent is the procuring cause of a sale, a lease, a rental, or another agreement. Both principal and agent owe certain duties to third persons. Both must make full disclosure of all material facts and defects affecting the desirability of the property. Both must inspect the property and reveal its condition to a potential buyer. The agent must not make a secret profit at the expense of a third person. The recovery account has been formed to help compensate victims of misconduct by real estate licensees. Open for discussion. In some large real estate offices, the broker of record manages the work of many associate licensees. 1. Do you think there should be a limit on the number of licensees that are supervised by one broker? 2. If so, what should that limit be? California_E_principles_10E_book.int 169 the 23rd of May 2017 2:27 and 14 seconds p.m. 170 California Real Estate Principles 10th edition Review Questions 1. Generally an agent works for A. the principal, B. the third person, C. the subagent, D. the California Bureau of Real Estate. 2. A minor A. may be a licensed real estate agent. B. is anyone younger than 21 years of age. C. may be a licensed real estate salesperson. D. is anyone younger than 18 years of age. 3. Someone appointed to carry out a particular transaction is A. a general agent. B. a special agent. C. a secret agent. D. a subagent. 4. An independent contractor is distinguished by A. responsibility for Social Security and other payments. B. no flexibility in setting work hours. C. little control over work methods. D. no legal obligation to employer. 5. The California real estate law treats a real estate salesperson as A. an independent contractor of the broker. B. an employee of the broker. C. a sole proprietor. D. a partner of the broker. 6. A salesperson is a broker's A. principal. B. agent. C. subagent. D. third person. 7. An agency agreement to perform an act that requires a writing A. must itself be in writing. B. may be or a law written. C. cannot be an express agreement. D. violates the statute of frauds. 8. To be enforceable, all real estate sales contracts A. may be or a law written. B. must be in writing. C. must comply with the equal equities rule. D. must be completed within 90 days of origination. 9. As a contract, a real estate agency agreement A. can have any objective. B. needs only to be made by parties with the capacity to contract. C. does not need to be supported by consideration. D. must meet the requirements for a valid contract. 10. Real estate commission rates A. are established by the California Bureau of Real Estate. B. should be no lower than 2%. C. should be no higher than 10%. D. are not fixed by law. 11. All real estate agency agreements must A. expire in 90 days. B. be in writing. C. be signed before a buyer is solicited. D. be approved by the California Bureau of Real Estate. 12. The most commonly used form of real estate listing agreement is A. the open listing. B. the exclusive agency listing. C. the exclusive authorization and right to sell listing. D. the net listing. 13. A real estate agent owes duties to A. the principal. B. the third person. C. the subagent. D. all of these. California_E_principles_10E_book.int 170 the 23rd of May 2017 2:27 and 15 seconds p.m. Unit 6 The Law of Agency 171 14. The agent owes the principal the duty of A. loyalty. B. compensation. C. Extraordinary care and skill. D. Dual representation. 15. A real estate agent must make full disclosure of a. All material facts known by the agent. B. All material facts revealed by the owner of the property. C. Material facts that are known by their agent or that would be revealed by a reasonable inspection of the property. D. All actual or potential property defects, of whatever kind. 16. The principal owes the agent a. Only the duty of compensation. B. The duty of obedience. C. The duty of care. D. The duties of a fiduciary. 17. A real estate seller must disclose a. Only visible property defects. B. Structural additions or repairs only if made by the seller. C. Material facts concerning the property's value or desirability. D. Only defects that would be revealed by a property inspection. 18. Exaggerating a property's value or desirability. A. Is permissible. B. Is expected in the average transaction. C. Is justifiable as harmless puffing. D. Is never permitted. 19. The recovery account is available to a. Brokers. B. Salespeople. C. People victimized by a real estate licensee. D. Real estate licensees victimized by their clients. 20. An agency relationship may not be terminated by a. Completion of the agreement. B. Expiration of the terms of the agreement. C. Agreement of the parties. D. Someone outside the agency relationship. The concept of agency. Whom does the real estate agent represent? In the traditional view of agency law, the agent most often represented the seller. This was true even when it was the buyer who first contacted the real estate agent. The buyer could be shown dozens of homes and helped through a complicated real estate purchase contract. The agent could even assist the buyer through the escrow process. Despite all that, the real estate agent was first and foremost the agent of the seller. Most buyers never realized that their agent was the seller's agent. It probably never occurred to the agent that the buyer should know. The traditional view of agency law in California has changed. Recent studies, public opinion, court decisions, legislation, and the redefinition of the marketplace thanks to the Internet have brought the role of the real estate agent into sharper focus. As the agency relationship is more clearly defined, it becomes easier for all agents to recognize and meet the challenges of that relationship. The real estate agent can better serve both buyers and sellers when all parties concerned know exactly whom the agent represents. The California Civil Code provides most of the laws dealing with the formation of an agency relationship. The definitions that follow and most of the information in this unit can be found there. To read a specific section of the law, go to www.leginfo.car.gov. As you read through this unit, remember that the law, no matter how well established by statute or precedent, is always subject to change. www.leginfo.car.gov. California_E_principles_10E_UO6.IND128 the 6th of January 2017 12:42 and 31 seconds p.m. Unit 6 The Law of Agency 129 What an agency is. An agent represents a principal in dealing with a third person. The act of representing someone else is called an agency. California Civil Code Section 2079.13 A defines the agent in a real estate transaction as the broker under whose license a listing is executed or an offer to purchase is obtained. It is important to remember that all of a real estate brokerage's associate licensees, real estate salespersons or brokers who work under the supervision of the company's designated broker, including those who work in branch offices, are considered one agent for the purpose of agency duties and liabilities. In the practice of real estate, there are many possible agency relationships. The listing broker acts as the agent of the seller, but the salesperson is the agent of their broker. There may be a different broker representing the buyer, and that broker may have a salesperson as his agent, who may take part in an agency relationship. In every agency relationship, there is always a principal, an agent, and a third person with whom the agent conducts business on behalf of the principal. The principal can be anyone who has the ability to enter into a contract. For example, A person who is mentally incompetent cannot enter into a valid agency relationship. In California, as in all states, a real estate agent must obtain the appropriate license. All California real estate licensees must be at least 18 years old and have fulfilled the education and other requirements discussed in Unit 1. A minor, someone under the age of 18, cannot obtain a real estate license. Special agent versus general agent. A special agent is one appointed to carry out a single act or transaction. Any other agent is called a general agent. The difference between a special agent and a general agent lies in the scope of authority the agent possesses. Typically, a general agent can enter into an agreement that will bind the principal to its terms, while the authority of a special agent will be subject to the approval of the principal. For example, broker Bob is engaged by Ramon and Rosa Garcia to sell their home. Bob is a special agent for that purpose. When he sells the Garcia home, his agency relationship with the Garcias will terminate. The Garcias, performers who are planning a move from Los Angeles to Las Vegas, employ a manager and give that person full authority to carry out their business affairs. What kind of agent is that person? That person is a general agent because of the broad authority given to the agent by the Garcias. California_E_Principles_10E_book.int 129 the 23rd of May 2017 2:26 and 52 seconds p.m. 1:30 California Real Estate Principles 10th edition. Delegating authority. Some of an agent's authority may be delegated to someone else. The agent may do so without express authority of the principal when the responsibility being delegated involves a clerical or administrative act. Other activities will require their principal's agreement before they can be delegated. For example, broker Meyer employs an administrative assistant, who performs secretarial duties, including typing sales brochures. Meyer's assistant performs none of the tasks that require a real estate license, such as soliciting property sellers and buyers. Meyer does not need the approval of her clients to employ her assistant. A complete discussion of real estate listing agreements appears later in this unit. The typical listing contract allows the listing broker to make use of the efforts of the listing broker's staff as well as the services of cooperating brokers. Cooperating brokers are agents who try to sell a property that is currently listed for sale by a broker but who work for someone other than the listing broker. Historically, it was taken for granted that the agency relationship was between their listing broker and the seller. Any agent who wrote an offer on behalf of a buyer was considered a subagent of the seller's broker, and, with the seller's consent, the listing broker agreed to share the commission with the subagent. Unless subagency was rejected, the cooperating broker was automatically the subagent of the seller and owed all the duties of a fiduciary to the seller. Under the practice of subagency, the buyer was not represented by the cooperating broker but instead was assisted by the cooperating broker. The problem: almost 70% of buyers believed the agent working with them was working for them. In reality, the buyer was the third party in an agency relationship, and all the agents were loyal to the seller. California legislation has changed this relationship. The cooperating broker is no longer automatically the subagent of the seller, even though the cooperating broker may be entitled to a share of the commission that the listing agent receives from the seller. The cooperating broker's share of the commission is called the cooperating split, or commission to the selling office. Now, a cooperating broker may be the agent of the listing broker, the subagent of the seller, with the seller's authorization, typically through use of the multiple listing service, or the agent of the buyer. It is important to remember that the seller's authorization does not necessarily require a written agreement. As you will learn later in this unit, in the section entitled How an Agency Relationship is Created, the conduct of the seller, the principal, also can authorize an agency relationship. Multiple Listing Service. A multiple listing service, MLS, is an organization of real estate agents that receives information from individual members on their property listings and makes that information available to participating members. California_E_Principles_10E_book.int 130 the 23rd of May 2017 2:26 and 52 seconds p.m. Unit 6. The Law of Agency. 131 MLS members agree to abide by the rules of the MLS. The MLS benefits sellers by making more agents aware of the availability of their property. Buyers benefit from a wide choice of properties from which an agent can present those that meet the buyer's needs. When a real estate broker enters into a listing agreement with a property owner, the owner may authorize the agent to place the listing in the MLS. Information placed in the MLS informs other agents of the asking price, provides a property description, indicates how the property may be shown, and tells the agent representing a buyer or the cooperating broker what the commission to the selling agent will be. The cooperating broker is entitled to the compensation offered in the MLS, regardless of agency relationships. The MLS listing will also inform other agents if subagency is optional or mandatory. A pocket listing is one that the listing agent markets privately before entering it in the MLS, unless specifically authorized by the seller. This practice usually is a violation of MLS rules as well as the employing broker's policies. For example, Broker Bob is the exclusive agent for the O'Connors, who are selling a 4-unit apartment building. The MLS has not been authorized and is not being used, although the property is being advertised for sale. If a cooperating broker brings in a buyer, what is the relationship of that broker to the O'Connors and Broker Bob? In this case, a cooperating broker would be the subagent of Broker Bob and have no direct relationship with the O'Connors. Employment relationship of principal and agent. An agency agreement is a form of employment contract. It can be structured in several ways. The principal is the employer, but the agent may act as either an employee or an independent contractor. The main difference is in the type of control the principal exercises over the agent. Another difference is the form of compensation paid to the agent. An employee typically is under very close control as to the place where work is performed, the hours spent on the work, and the manner in which the work is carried out. An employee receives wages from which payroll taxes are deducted and may receive other employee benefits. Employee status also subjects the employer to certain liability for acts performed in the course of employment, which will be discussed later. An independent contractor, on the other hand, usually has great flexibility in accomplishing the task undertaken and will receive a commission based on completed transactions, instead of a salary, with no payroll deductions. Real estate agents generally act as independent contractors in their dealings with clients as well as in their dealings with each other. Real estate sales associates don't have a typical 9-to-5 job with evenings and weekends off. California_E_principles_10E_book.int 131 the 23rd of May 2017 2:26 and 52 seconds p.m. 132 California Real Estate Principles 10th edition. Don't forget, a real estate salesperson can conduct business only as the agent of a broker and they must have a written employment agreement. The real estate license law always considers a salesperson to be an employee acting under the direct supervision and control of the broker. This is true even when the salesperson is treated by the broker as an independent contractor for compensation, work assignment, and tax purposes. For example, CPU Home Loans has a staff of 12 salespeople, all of whom are assigned office time and all of whom are paid a salary plus a commission on sales. CPU deducts income taxes and Social Security from the salaries of all salespeople and also makes payments for unemployment insurance and workers' compensation. For purposes of work assignments and compensation, are the salespeople of CPU Home Loans employees or independent contractors? The salespeople of CPU Home Loans clearly are employees. Throughout the rest of this unit, we will refer to the role of the real estate broker rather than that of the real estate salesperson. Keep in mind that a salesperson acts always as the agent of the employing broker and that someone with a broker's license may choose to be employed by another broker. A real estate licensee employed by the broker will be referred to as an associate licensee. All of the associate licensees in a real estate brokerage, including all branch offices, are considered one agent for the purpose of agency duties and liabilities. The designated broker is responsible for all acts of the associate licensee with regard to duties owed to the principal, third party, and other brokers. In most cases, all of the listings in a real estate company belong to the broker and not the associate licensee. If an associate licensee changes employing brokers, The listings stay with the broker under whose name they were taken, unless the broker allows the associate licensee to retain them. Single versus dual agency. In a single agency, an agent represents only one principal. Each principal in a transaction is represented by a different broker, as shown in Figure 6.1. In a dual agency, the same agent represents two principals in the same transaction. A listing broker may find a buyer for the property. A dual agency can also occur when two associate licensees in the same brokerage work on behalf of the employing broker to represent both buyer and seller. 133. Figure 6.1. Agency relationships. Seller-buyer, customer listing broker, associate licensee, seller-buyer, client. Single agency, dual agency, seller-buyer. Solid lines indicate agency relationships. Dotted lines indicate non-agency relationships. Listing broker associate licensee. Listing broker associate licensee. Buyer-s broker associate licensee. A dual agency places the agent in a precarious position of carrying out agency responsibilities to two principals whose interests are in opposition. Any agent who acts on behalf of both parties to a transaction is required by law to inform both parties and obtain their written consent to the dual representation. The law is very specific with regard to the activities of real estate agents. A real estate broker in a dual agency relationship must make sure that both clients know of and consent to the dual representation. Otherwise, the agent faces temporary suspension or even permanent revocation of the real estate license, in addition to having to return any commission received on the transaction. The penalty may seem severe, but the chance or even the appearance of taking advantage of the special knowledge an agent possesses makes a dual agency a difficult enterprise. Not only does the broker have a real estate license to consider, a party acting without knowledge of the dual agency also could ask the court to rescind any contract that results. Agency Disclosure Form. As of January 1, 1988, the details of the agency relationship must be disclosed in any transaction involving property of 1 to 4 residential units. A written document that explains the various relationships of those involved in a residential property sale, and exactly whom the agent is representing, must be presented to both buyer and seller as soon as practicable. Their written disclosure must be made by either listing agent to the seller before the seller signs the listing agreement. California_E_principles_10E_book.int 133 the 23rd of May 2017 2:26 and 54 seconds p.m. 134 California Real Estate Principles 10th edition. Other selling agent, who may also be the listing agent, to the buyer before the buyer makes an offer to purchase, and other selling agent, if different from the listing agent, to the seller before an offer to purchase is accepted. An example of an agency disclosure form is shown in Figure 6.2. The wording of the form must follow the wording required by Civil Code Section 2375. In addition, the rest of the code sections dealing with the disclosure requirements must be printed on the back of the form. The selling agent's relationship must be confirmed in writing in either purchase contract or a separate writing executed or acknowledged by the seller, the buyer, and the selling agent before or at the same time the purchase contract is executed by buyer and seller. The listing agent's relationship must be confirmed in writing in either purchase contract or a separate writing executed or acknowledged by the seller and the listing agent before or at the same time the purchase contract is executed by the seller. The agency disclosure form shown here makes clear that, in addition to listing and sales transactions, agency disclosure obligations apply to a lease of a dwelling when the lease term will exceed 1 year. An example of an agency confirmation form is shown in Figure 6.3. The most recent revision of this form allows for its use by licensees representing landlord and/or tenant as well as seller and/or buyer. Power of attorney. An attorney at law is someone licensed by the state to practice law. An attorney in fact is an agent who has been granted a power of attorney by a principal. A power of attorney authorizes an agent to act in the capacity of the principal. California_E_principles_10E_book.int 130 134, the 23rd of May 2017, 2:26 and 54 seconds p.m. Unit 6, the Law of Agency 135, Figure 6.2. Disclosure regarding real estate agency relationship. Sample California Association of Realtors, a registered disclosure regarding real estate agency relationship, as required by the Civil Code, CAR Format, Revised 1214. Disclosure regarding real estate agency relationship, add page 1 of 2, add Revised 1214, page 1 of 2, print date. The copyright laws of the United States, Title 17 U.S. Code, forbid the unauthorized reproduction of this form, or any portion thereof, by photocopy machine or any other means, including facsimile or computerized formats. Copyright 1991 to 2010, California Association of Realtors, a registered, incorporated. All rights reserved. Reviewed by _date_Q, if checked. This form is being provided in connection with a transaction for a leasehold interest exceeding 1 year as per Civil Code Section 2079.13 K, L, and M. When you enter into a discussion with a real estate agent regarding a real estate transaction, you should from the outset understand what type of agency relationship or representation you wish to have with the agent in the transaction. Seller's agent. A seller's agent under a listing agreement with the seller acts as the agent for the seller only. A seller's agent or a sub-agent of that agent has the following affirmative obligations: to the seller, a fiduciary duty of utmost care, integrity, honesty and loyalty in dealings with the seller. To the buyer and the seller, a diligent exercise of reasonable skill and care in performance of the agent's duties. B. A duty of honest and fair dealing and good faith. C. A duty to disclose all facts known to the agent materially affecting the value or desirability of the property that are not known to, or within the diligent attention and observation of, the parties. An agent is not obligated to reveal to either party any confidential information obtained from the other party that does not involve the affirmative duties set forth above. Buyer's agent. A selling agent can, with a buyer's consent, agree to act as agent for the buyer only. In these situations, the agent is not the seller's agent, even if by agreement the agent may receive compensation for services rendered, either in full or in part from the seller. An agent acting only for a buyer has the following affirmative obligations: to the buyer, a fiduciary duty of utmost care, integrity, honesty and loyalty in dealings with the buyer. To the buyer and the seller, a diligent exercise of reasonable skill and care in performance of the agent's duties. B. A duty of honest and fair dealing and good faith. C. A duty to disclose all facts known to the agent materially affecting the value or desirability of the property that are not known to, or within the diligent attention and observation of, the parties. An agent is not obligated to reveal to either party any confidential information obtained from the other party that does not involve the affirmative duties set forth above. Agent representing both seller and buyer. A real estate agent, either acting directly or through one or more associate licensees, can legally be the agent of both the seller and the buyer in a transaction, but only with the knowledge and consent of both the seller and the buyer. In a dual agency situation, the agent has the following affirmative obligations to both the seller and the buyer: a fiduciary duty of utmost care, integrity, honesty and loyalty in the dealings with either the seller or the buyer. B. Other duties to the seller and the buyer as stated above in their respective sections. In representing both seller and buyer, the agent may not, without the express permission of the respective party, disclose to the other party that the seller will accept a price less than the listing price or that the buyer will pay a price greater than the price offered. The above duties of the agent in a real estate transaction do not relieve a seller or buyer from the responsibility to protect his or her own interests. You should carefully read all agreements to assure that they adequately express your understanding of the transaction. A real estate agent is a person qualified to advise about real estate. If legal or tax advice is desired, consult a competent professional. Throughout your real property transaction you may receive more than one disclosure form, depending upon the number of agents assisting in the transaction. The law requires each agent with whom you have more than a casual relationship to present you with this disclosure form. You should read its contents each time it is presented to you, considering the relationship between you and the real estate agent in your specific transaction. This disclosure form includes the provisions of sections 2079.13 to 2079.24, inclusive of the Civil Code set forth on page 2. Read it carefully. We acknowledge receipt of a copy of this disclosure and the portions of the Civil Code printed on the back, or a separate page. Buyer/seller/landlord/tenant_date_buyer/seller/landlord/tenant_agent_BRE #real estate broker, firm, by_BRE lic #date_ salesperson or broker associate. Agency disclosure compliance, Civil Code A Section 2079.14. Since when the listing brokerage company also represents buyer/tenant, the listing agent shall have one ad form signed by seller, landlord and a different ad form signed by buyer, tenant. Since when seller, landlord and buyer, tenant are represented by different brokerage companies, the listing agent shall have one ad form signed by seller, landlord and, 2, the buyer'/tenant's agent shall have one ad form signed by buyer, tenant and either that same or a different ad form presented to seller, landlord for signature prior to presentation of the offer. If the same form is used, seller may sign here, __seller, landlord date seller, landlord date. Source, reprinted with permission, California Association of Realtors A registered. Endorsement not implied. California_E_principles_10E_book.int 135 the 23rd of May 2017 2:26 and 58 seconds p.m. 136 California Real Estate Principles 10th edition Figure 6.2, Disclosure regarding real estate agency relationship. Continued. Sample Civil Code Sections 2079.24, 2079.16 appears on the front. Disclosure regarding real estate agency relationship, add page 2 of 2, add revised 1214, page 2 of 2. Reviewed by _date_, published and distributed by Real Estate Business Services, Incorporated, a subsidiary of the California Association of Realtors A registered. 525 South Virgil Avenue, Los Angeles, California 90020. 2079.13 as used in sections 2079.14 to 2079.24, inclusive. The following terms have the following meanings. A. Agent means a person acting under provisions of Title IX, commencing with Section 2295, in a real property transaction, and includes a person who is licensed as a real estate broker under Chapter 3, commencing with Section 10130, of Part 1 of Division 4 of the Business and Professions Code, and under whose license a listing is executed or an offer to purchase is obtained. B. Associate licensee means a person who is licensed as a real estate broker or salesperson under Chapter 3, commencing with Section 10130, of Part 1 of Division 4 of the Business and Professions Code and who is either licensed under a broker or has entered into a written contract with a broker to act as the broker's agent in connection with acts requiring a real estate license and to function under the broker's supervision in the capacity of an associate licensee. The agent in the real property transaction bears responsibility for his or her associate licensees who perform as agents of the agent. When an associate licensee owes a duty to any principal, or to any buyer or seller who is not a principal, in a real property transaction, that duty is equivalent to the duty owed to that party by the broker for whom the associate licensee functions. C. Buyer means a transferee in a real property transaction, and includes a person who executes an offer to purchase real property from a seller through an agent, or who seeks the services of an agent in more than a casual, transitory, or preliminary manner, with the object of entering into a real property transaction. Buyer includes vendee or lessee. D. Commercial real property means all real property in the state, except single-family residential real property, dwelling units made subject to Chapter 2, commencing with Section 1940, of Title 5, Mobile Homes, as defined in Section 798.3, or recreational vehicles, as defined in Section 799.29. E. Dual agent means an agent acting, either directly or through an associate licensee, as agent for both the seller and the buyer in a real property transaction. F. Listing agreement means a contract between an owner of real property and an agent, by which the agent has been authorized to sell the real property or to find or obtain a buyer. G. Listing agent means a person who has obtained a listing of real property to act as an agent for compensation. H. Listing price is the amount expressed in dollars specified in the listing for which the seller is willing to sell the real property through the listing agent. I. Offering price is the amount expressed in dollars specified in an offer to purchase for which the buyer is willing to buy the real property. J. Offer to purchase means a written contract executed by a buyer acting through a selling agent that becomes the contract for the sale of the real property upon acceptance by the seller. K. Real property means any estate specified by subdivision 1 or 2 of Section 761. In property that constitutes or is improved with 1 to 4 dwelling units, any commercial real property, any leasehold in these types of property exceeding 1 year's duration, and mobile homes, when offered for sale or sold through an agent pursuant to the authority contained in Section 10,131.6 of the Business and Professions Code. L. Real property transaction means a transaction for the sale of real property in which an agent is employed by one or more of the principals to act in that transaction, and includes a listing or an offer to purchase. M. Sell, sale, or sold refers to a transaction for the transfer of real property from the seller to the buyer, and includes exchanges of real property between the seller and buyer, transactions for the creation of a real property sales contract within the meaning of Section 2985, and transactions for the creation of a leasehold exceeding 1 year's duration. N. Seller means the transferor in a real property transaction, and includes an owner who lists real property with an agent, whether or not a transfer results, or who receives an offer to purchase real property of which he or she is the owner from an agent on behalf of another. Seller includes both a vendor and a lessor. O. Selling agent means a listing agent who acts alone, or an agent who acts in cooperation with a listing agent, and who sells or finds and obtains a buyer for the real property, or an agent who locates property for a buyer or who finds a buyer for a property for which no listing exists and presents an offer to purchase to the seller. P. Subagent means a person to whom an agent delegates agency powers as provided in Article 5, commencing with Section 2349, of Chapter 1 of Title 9. However, subagent does not include an associate licensee who is acting under the supervision of an agent in a real property transaction. 2079.14 Listing agents and selling agents shall provide the seller and buyer in a real property transaction with a copy of the disclosure form specified in Section 2079.16, and, except as provided in subdivision C, shall obtain a signed acknowledgement of receipt from that seller or buyer, except as provided in this section or Section 2079.15, as follows. A. The listing agent, if any, shall provide the disclosure form to the seller prior to entering into the listing agreement. B. The selling agent shall provide the disclosure form to the seller as soon as practicable prior to presenting the seller with an offer to purchase, unless the selling agent previously provided the seller with a copy of the disclosure form pursuant to subdivision A. C. Where the selling agent does not deal on a face-to-face basis with the seller, the disclosure form prepared by the selling agent may be furnished to the seller, and acknowledgement of receipt obtained for the selling agent from the seller, by the listing agent, or their selling agent may deliver the disclosure form by certified mail address to the seller at his or her last known address, in which case no signed acknowledgement of receipt is required. D. The selling agent shall provide the disclosure form to the buyer as soon as practicable prior to execution of the buyer's offer to purchase, except that if the offer to purchase is not prepared by the selling agent shall present the disclosure form to the buyer not later than the next business day after the selling agent receives the offer to purchase from the buyer. 2079.15 In any circumstance in which the seller or buyer refuses to sign an acknowledgement of receipt pursuant to Section 2079.14, the agent or an associate licensee acting for an agent shall set forth, sign, and date a written declaration of the facts of the refusal. 2079.16 Reproduced on page 1 of this ad form. 2079.17a As soon as practicable, the selling agent shall disclose to the buyer and seller whether the selling agent is acting in the real property transaction exclusively as the buyer's agent, exclusively as the seller's agent, or as a dual agent representing both the buyer and the seller. This relationship shall be confirmed in the contract to purchase and sell real property or in a separate writing executed or acknowledged by their seller, the buyer, and the selling agent prior to or coincident with execution of that contract by the buyer and the seller, respectively. B. As soon as practicable, the listing agent shall disclose to the seller whether the listing agent is acting in the real property transaction exclusively as their seller's agent, or as a dual agent representing both the buyer and seller. This relationship shall be confirmed in the contract to purchase and sell real property or in a separate writing executed or acknowledged by the seller and the listing agent prior to or coincident with the execution of that contract by the seller. C. The confirmation required by subdivisions A and B shall be in the following form. Do not complete. Sample only. Is the agent of Check 1. Q the seller exclusively or Q both the buyer and seller. Name of listing agent. Do not complete. Sample only. Is the agent of Check 1. Q the buyer exclusively or Q the seller exclusively, or name of selling agent if not the same as the listing agent, Q both the buyer and seller. D. The disclosures and confirmation required by this section shall be in addition to the disclosure required by Section 2079.14, 2079.18. No selling agent in a real property transaction may act as an agent for the buyer only, when the selling agent is also acting as the listing agent in the transaction. 2079.19. The payment of compensation or the obligation to pay compensation to an agent by the seller or buyer is not necessarily determinative of a particular agency relationship between an agent and the seller or buyer. A listing agent and a selling agent may agree to share any compensation or commission paid, or any right to any compensation or commission for which an obligation arises as the result of a real estate transaction, and the terms of any such agreement shall not necessarily be determinative of a particular relationship. 2079.20. Nothing in this article prevents an agent from selecting, as a condition of the agent's employment, a specific form of agency relationship not specifically prohibited by this article if the requirements of Section 2079.14 and Section 2079.17 are complied with. 2079.21. A dual agent shall not disclose to the buyer that the seller is willing to sell the property at a price less than the listing price, without their express written consent of the seller. A dual agent shall not disclose to the seller that the buyer is willing to pay a price greater than the offering price, without the express written consent of the buyer. This section does not alter in any way the duty or responsibility of a dual agent to any principal with respect to confidential information other than price. 2079.22 Nothing in this article precludes a listing agent from also being a selling agent, and the combination of these functions in one agent does not, of itself, make that agent a dual agent. 2079.23 A contract between the principal and agent may be modified or altered to change the agency relationship at any time before the performance of the act which is the object of the agency with the written consent of the parties to the agency relationship. 2079.24 Nothing in this article shall be construed to either diminish the duty of disclosure owed buyers and sellers by agents and their associate licensees, subagents, and employees, or to relieve agents and their associate licensees, subagents, and employees from liability for their conduct in connection with acts governed by this article, or for any breach of a fiduciary duty or a duty of disclosure. Source: reprinted with permission, California Association of Realtors. A registered endorsement not implied. California_E_principles_10E_book.int 136 the 23rd of May 2017 2:26 and 58 seconds p.m. Unit 6 The Law of Agency 137 A special power of attorney gives an agent authority to carry out a specific act or acts. A general power of attorney authorizes an agent to carry out all of the business dealings of the principal. Exercise 6.1 The following case problems illustrate some of the concepts you have just learned. Identify those concepts and answer the questions asked about them. 1. Glenda Golden has been declared mentally incompetent and resides in a nursing home. Her parents, who have moved to Retirement City, transferred title to their ranch to a trust established for Glenda, their only heir. Glenda learns of this and contacts Helen Silver, leading salesperson for Keysafe Realty, about selling the ranch. Helen knows the property will sell quickly. Should Helen take the listing? 2. All of the salespeople at ABC Real Estate work strictly on commission. No deductions are made from their commissions, which they share with ABC. They have no office duties and are billed for any use of secretarial staff, phones, conference rooms, and so on. They do receive referrals from ABC, which they can accept or reject. Describe the relationship between ABC Real Estate and its salespeople. 3. Salesperson Sam is a good friend of the Patels, who asks Sam to help them find a small office building for their mail order business. The Patels tell Sam they will pay him $1,000 as a fee if within 30 days he can find a suitable building available for occupancy. The Patels and Sam sign a written agency agreement to that effect. The next day, Sam is approached by Jim Nelson, who wishes to sell an office building that meets the Patels' specifications exactly. Can Sam sign an agency agreement on behalf of his broker with Jim Nelson? In other words, can he list the Nelson property for sale? If Sam lists the Nelson property, can he then show that property to the Patels? Should he? How an agency relationship is created. The agreement between principal and agent that forms the basis of the agency may come about in one of several ways. This section discusses the creation of an agency relationship by A. express agreement, A. ratification, and A. estoppel. 138 California Real Estate Principles 10th edition Figure 6.3 Agency Confirmation Form. Confirmation of real estate agency relationships, as required by the Civil Code, CAR. Form AC, revised 0408. CLFORNIA as SOCIATION of REALTO RSA registered. Sample. Confirmation Real Estate Agency Relationships, AC page 1 of 1, published and distributed by Real Estate Business Services, Incorporated, a subsidiary of the California Association of Realtors. A registered, 525 South Virgil Avenue, Los Angeles, California 90020. Reviewed by _date _subject property address _ the following agency relationships are hereby confirmed for this transaction. Listing agent _ is the agent of check 1, the seller/landlord exclusively or both the buyer, tenant and seller, landlord selling agent, _, if not the same as listing agent, is the agent of, check 1, the buyer, tenant exclusively or the seller, landlord exclusively or both the buyer, tenant and seller, landlord I, we acknowledge receipt of a copy of this confirmation. Seller, landlord _date _seller, landlord _date _buyer, tenant _date _buyer, tenant _date _real estate broker, selling firm, _by _date _real estate broker, listing firm, _by _date _. A real estate broker is qualified to advise on real estate. If you desire legal advice, consult your attorney. This form is available for use by the entire real estate industry. It is not intended to identify the user as a Realtor A registered. Realtor A registered is a registered collective membership mark which may be used only by members of the National Association of Realtors A registered who subscribe to its Code of Ethics. The copyright laws of the United States, 17 U.S. Code, forbid the unauthorized reproduction of this form by any means, including facsimile or computerized formats. Copyright 1987 to 2008, California Association of Realtors A registered. Print firm name. Source, reprinted with permission, California Association of Realtors A registered. Endorsement not implied. California _E principles _10E book.int 138 the 23rd of May 2017 2:27 and 1 p.m. Unit 6 The Law of Agency 139 Express Agreement. An express agreement is established by an act of the parties that both parties acknowledge. The agreement does not have to be in writing, unless either law requires a writing, or the agent is to perform an act on behalf of the principal that requires a writing. This is known as the equal dignities rule. An agency permitting an agent to establish such a contract for the principal must itself be in writing. The Statute of Frauds stipulates the kinds of contracts that must be written to be enforceable. 3 rules applicable to real estate are summarized as follows. 1. The California real estate law requires that the employment agreement between a real estate broker and salesperson be in writing. 2. The Statute of Frauds dictates that a contract for the sale of real estate or the lease of real estate for longer than 1 year must be in writing. This means that any agency agreement authorizing those actions must be written. 3. The Statute of Frauds also requires that a contract that authorizes an agent to find a purchaser or lessee, for more than 1 year, of real estate or a listing agreement to be written. Ratification. An agency could also be established by a subsequent ratification, authorization, by either the principal or the agent of an activity of the other that held out an agency relationship. For example, broker Al Teller knows that his neighbor Woody is trying to sell a small lot in the downtown area that is zoned for commercial use. Because of its size, the lot is worth about $5,000. Al offers to find a buyer if he is given a 10% commission. Woody does not make a commitment but says he will think it over. The next day at a Chamber of Commerce luncheon, Joe Everett mentions to Al that he is looking for a small lot downtown to open a sandwich shop. Al tells Joe about his neighbor's property, and Joe is enthusiastic. Later that day, Al brings Joe to see the lot, and Joe states that he is willing to offer $4,500 for it. Al brings Joe's offer to Woody. If Woody accepts Joe's offer, will he have to pay Al a commission? If Woody accepts the offer, he will ratify an agency agreement with Al on the terms discussed earlier. Caution: if an agency agreement for the sale of real estate is formed by ratification, the ratification must be in writing and comply with all of the other formalities that would ordinarily be required for a valid real estate contract. California _E principles _10E book.int 139 the 23rd of May 2017 2:27 and 1 p.m. 140 California Real Estate Principles 10th edition estoppel. Another way to form an agency by operation of law is by estoppel. Someone may represent that another person is her agent, and a third person may rely on that representation and deal with the agent accordingly. If so, the principal will not be able to evade the agency relationship. An agency created by estoppel is also called an ostensible agency or implied agency. For example, Smith tells Jones that broker Bob is selling the Smith home. Jones brings an offer to Bob, who prepares a written offer to purchase, listing himself as the broker and stipulating a commission rate. Smith can accept the offer by signing it. If he does so, will an agency be created? Yes, if Smith accepts the offer, which lists broker Bob as the selling agent entitled to the sales commission. Smith's acceptance by signing the agreement would satisfy the requirement for a writing. Exercise 621. Richard and Roberta Simpson have decided to sell their condominium in Long Beach. They talk to broker Bonita, who does a market analysis for them and recommends a selling price in the $380,000 a $400,000 range. Richard and Roberta tell Bonita they will think it over, but if they decide to sell, they will want to ask for $410,000, so that they will have at least $380,000 left after paying the sales commission and closing costs. Is broker Bonita the Simpsons' agent? 2. The next day, Bonita calls the Simpsons and tells them that an out-of-town buyer, anxious to close a deal on a condominium, is in her office and would like to see their home. The Simpsons allow Bonita to bring the prospective buyer through their condominium. Is broker Bonita the Simpsons' agent? 3. The out-of-town buyer makes an offer, through Bonita, of $395,000. The real estate purchase contract, signed by the buyer and broker Bonita, lists Bonita as selling broker, to receive a 6% commission on the sale. After talking it over, the Simpsons decide the offer is a good one, and they accept it by signing the contract. Is broker Bonita the Simpsons' agent? Agency agreements. An agreement creating an agency is a form of contract. Unit 1 included an example of an independent contractor agreement between broker and associate licensee. This section begins with a discussion of general contract requirements. Then, the types of listing agreement are explained. Finally, examples of a listing agreement and a buyer brokerage agreement are discussed. California_E_Principles_10E_book.int 140 the 23rd of May 2017 2:27 and 1 second p.m. Unit 6 The Law of Agency 141 Requirements for a valid contract. A real estate agency agreement must comply with the following legal requirements to create a valid contract, discussed in detail in Unit 7. The agency agreement must be made by parties who have the capacity to contract. Both parties must consent to the terms of the contract. The contract must have the lawful objective. There must be consideration that is, an obligation on both parties. A real estate listing agreement generally requires the broker, the agent, to find a buyer. If a buyer is found, the seller, the principal, will be required to pay the agent a commission based on the sales price agreed on by the seller and buyer. If all of the above requirements are met, a bilateral contract has been formed. Each party to the contract has a separate obligation to perform, as provided in the contract. When only one party has an obligation under the contract, a unilateral contract is formed. A seller of real estate, for example, must pay a commission if the broker finds a ready, willing, an able buyer. But if a listing agreement is a unilateral contract, the broker is not obligated to exert any effort to find such a buyer. For obvious reasons, unilateral contracts to sell real estate are not common in California. Listing agreements as well as other agency agreements, such as the broker-salesperson contract discussed in this unit, require the agent to use due diligence in carrying out the purpose of the contract. For example, salesperson Sam signs a broker-salesperson contract with broker Bob. Sam is to use due diligence in handling the listings of Bob's company. In return, Sam will receive a percentage of the commission on every sale he makes. What is Bob's obligation under the contract? What is Bob's obligation if Sam fails to sell, lease, or rent any listings? Broker Bob will pay salesperson Sam a share of the commission received on a completed transaction. Bob has no obligation to pay Sam unless Sam brings about a sale or other transaction. The real estate agent's commission in California, Real estate commissions are negotiable. There is no predetermined commission rate. A seller and broker are free to set whatever rate they agree on. Authority of an agent. The actual authority of an agent is what is specified in the agency agreement. An agent can be given authority to do any lawful thing short of a personal act that only the principal can perform. A real estate agent, for example, can be authorized. Due diligence implies a good faith effort to fulfill contract obligations. California_E_principles_10E_book.int 141 the 23rd of May 2017 2:27 and 1 p.m. 142 California Real Estate Principles 10th edition. To conduct an open house but will not be able to order repair work done on the property. An agent's authority may be broadened in an emergency, if immediate action is required and the principal is unavailable. A typical real estate listing agreement specifies the obligation of the broker in soliciting offers. Under a broker salesperson contract, a salesperson is employed by a broker, for compensation or in expectation of compensation, to perform an act the broker could perform. An agent also has inherent authority, depending on the nature of the agent's obligations. There always are activities the agent needs to perform that are not mentioned in the contract, no matter how detailed. In conducting an open house, for instance, a real estate licensee may advertise, distribute flyers in the neighborhood, and post signs at nearby intersections, none of which is likely to be specified in the listing agreement. An agent may appear to have authority he does not have. This apparent authority places no obligation on the party the agent claims to represent, but it will make the agent liable for his representations. For example, broker Murphy meets Paula Phillips, who is looking for a house in Murphy's area. Paula describes what she wants, and Murphy realizes that his neighbor's house meets Paula's specifications exactly. Broker Murphy describes the house to Paula, who makes a special trip to town to see it. He did not tell Paula that the house he has described is not for sale. He is unable to persuade his neighbor that she should put her house up for sale, and he cannot reach Paula in time to call off her trip. Does Murphy have any liability to Paula? At the least, Murphy will be dealing with a disappointed customer, and he may have to pay her expenses in traveling to his area. At the worst, Paula will complain to the real estate commissioner, who may discipline Murphy for his misrepresentation. Handling deposits. One of a real estate licensee's most important obligations, as expressed in standard listing agreement forms, is to receive a deposit from a prospective buyer. The form of the deposit must be clearly disclosed to the seller and may influence the seller's decision to accept or reject the offer. For example, the offer may be accompanied by a demand note, pay-to-buy note, or post-dated check, either of which will be less desirable than an immediately negotiable check. Within 3 business days following receipt of deposit funds by the broker or broker's salesperson, if the funds have not been returned to their owner, they must be placed in a neutral escrow depository or in a trust fund account set up for the specific purpose of handling client and customer monies. A deposit check may be held uncashed by the broker until acceptance of the offer if either check is not negotiable by the broker, or the offeror has given written instructions that the check may not be deposited or cashed until acceptance of the offer, and the offeree is informed that the check is being held uncashed. 143 In most cases, the deposit is placed in an escrow account if the contract offer is accepted by the seller. If the offer is not accepted, the deposit is returned to the buyer. In either situation, the agent should make a record of the check's disposition. Unless specifically authorized by the seller in a listing or other agreement, a real estate broker or salesperson taking possession of a buyer's deposit is acting as the buyer's agent. A buyer's representative who agrees to transmit the buyer's deposit to a seller should make sure the deposit is made out correctly and held in a safe place until it is delivered. Above all, the real estate agent must avoid commingling funds. This occurs if the agent places client or customer funds in the agent's personal account. The real estate commissioner can bring disciplinary action for any violation of this rule. The easiest way to avoid problems is to have the deposit check made out to the escrow closing agent. Exercise 631. Frank Rice, a licensed real estate broker, lists the Marlowe house for sale. If Frank becomes ill and is unable to carry out the terms of his agreement, can he delegate that responsibility to another broker? 2. Broker Rice has received an offer on the Marlowe house along with a deposit check for $1,000, which his agency agreement authorizes him to receive. It is early evening when Rice receives the check, which he will present the offer to the seller the next morning. What should Rice do with the check in the meantime? 3. Broker Rice has been given a deposit check for $2,000 by a buyer. He neglected to tell the buyer to whom to make out the check, and the buyer made the check out to him. The buyer's offer is accepted. Broker Rice deposits the check in his personal account and immediately writes out his own check to the title company that will handle the sale. Has Broker Rice acted correctly? Listing agreements. An agreement establishing an agency relationship between a real estate property owner and a real estate broker, for the purpose of selling or buying real estate, must be in writing. A written agreement should be signed by both parties as soon as possible after the client has indicated a willingness to list property. The following box summarizes all forms of written real estate listing agreements. Note that all refer only to the real estate broker, because a salesperson, associate licensee, can act only on behalf of a broker. An associate licensee who acts with that authority can perform as the broker would in any of these situations. California_E_principles_10E_book.int 143 the 23rd of May 2017 2:27 and 1 p.m. 144 California Real Estate Principles 10th edition. Listing agreements. Open listing. Non-exclusive commission earned only if listing broker is procuring cause of sale. Exclusive agency listing. No other broker authorized owner may sell without owing commission. Exclusive authorization and right to sell listing. No other broker authorized cooperating broker may be brought in. Commission owed no matter who sells the property. Net listing. No other broker authorized seller receives predetermined amount and broker receives excess. Option listing. No other broker authorized broker has right to purchase the property. Requires full disclosure to seller of broker's profit if option exercised. Note also that there must be a definite termination date in any agreement that makes the listing broker the exclusive agent of the seller. The Business and Professions Code provides for suspension or revocation of a real estate license if the licensee claims, demands, or receives any compensation under any exclusive agreement, if the agreement does not contain a definite, specified date of final and complete termination. Open listing. An open listing, also called a non-exclusive listing, provides for a commission to the broker if the broker is the procuring cause of a sale. It provides no compensation if another broker fulfills that task or if the owner does. To be the procuring cause of a sale, the agent must be the one who brings the parties together or at least must initiate the contact that leads to a sale, because there is no assurance that the listing broker will be the one to sell the listed property. This form of listing generally is avoided in residential transactions. It is often used in industrial and commercial property transactions, however. Exclusive agency listing. With an exclusive agency listing, the property owner cannot list the property with another broker at the same time. The listing broker thus has the protection of getting at least a share of the commission if another broker finds a buyer. The protection is not complete, however, because California_E_principles_10E_book.int 144 the 23rd of May 2017 2:27 and 1 p.m. Unit 6. The Law of Agency 145. The owner still may find a buyer without the broker's assistance and thus avoid paying any commission. In effect, the listing may become a sale by owner. Exclusive authorization and right to sell listing. The most commonly used form of agreement, and the only one that will be accepted by most employing brokers, is the exclusive authorization and right to sell listing. With this type of listing, the broker is entitled to a commission no matter who sells the property, even if the owner appears to find a buyer without the broker's assistance. The buyer may have found the property address on the internet, for example, or may have seen a sign on the property and contacted the owner directly. The listing broker is the owner's agent but has the option of being a dual agent. The commission typically is shared with any cooperating broker or sub-agent who procures a buyer. This type of listing agreement usually contains a safety clause that will cover a buyer the broker is working with even after the listing expires. As long as the broker has registered that buyer with the owner, the contract will specify the length of time after the listing expires during which the broker may still be compensated, whether or not the owner signs a new listing agreement with a different broker. The multiple listing clause that is a part of the exclusive authorization and right to sell listing allows the property to be made available to other brokers participating in the MLS. The requirements of the broker's MLS determine whether the broker must place every listing into the MLS and how members of the MLS will be treated. For example, Lydia lists her residence for sale. Broker Aina has an MLS clause in her exclusive authorization and right to sell listing agreement with Lydia. If Broker Bob, a member of the MLS, finds a buyer, does Broker Aina deserve a commission? Yes. Broker Aina is entitled to the listing broker's share of the commission. Net listing. In a net listing, the broker's compensation is whatever amount the property sells for over a previously agreed net amount. If the selling price is equal to or less than the agreed on net listing amount, the broker receives no compensation before it is accepted by the seller. This kind of agreement requires full disclosure of the selling price and the amount of compensation the broker will receive. Without these disclosures, the broker and associate licensee may face license revocation or suspension. Because such an arrangement is both inherently risky, the broker may earn little or no compensation, and inherently suspect, a high commission may hint at a too low net listing price. It should be avoided. California_E_principles_10E_book.int 145 the 23rd of May 2017 2:27 and 1 p.m. 146 California Real Estate Principles 10th edition. For example, a property's owners are selling a buildable lot in Palm Springs, and want to receive $143,000 after the commission and all costs are paid. Broker Bob signs a net listing agreement with the owners, specifying that they are to receive $143,000 for their property. What is Broker Bob's commission if the property is sold for $158,000? For $147,000, $158,000 selling price, a $143,000 net listing price, $15,000, a $2,000 costs of sale, $13,000 broker's commission, $147,000 selling price, a $143,000 net listing price, $4,000, a $2,000 costs of sale, $2,000 broker's commission. Option listing. An option listing gives the broker the right to purchase the property. The broker thus can possibly be both a principal and agent in the same transaction. The broker must be scrupulous in fulfilling all obligations to the principal, particularly in informing the principal of all offers. If the broker exercises the option, the principal must be informed of the broker's profit in the transaction and agree to it in writing. Terms of the listing. Figure 6.4 is a typical exclusive authorization and right to sell listing contract. This form was prepared by the California Association of Realtors, registered. The features of the contract are explained in the following list. The numbered paragraphs refer to the numbered sections of the contract. 1. Spaces provided for the seller's name, the broker's name, the dates the listing will begin and end, the city and county in which the property is located, the assessor's parcel number, and a detailed enough description to exclude all other property. 2. Listing price is indicated in words and numbers. The seller's preferred purchase terms also can be indicated. 3. The commission rate on the sale of a single-family residence is negotiable. This fact is required by law to appear in the listing agreement. For property of 1 to 4 residential units. Section 3A2 is the broker's safety clause. The parties agree to a reasonable time after the expiration of the listing agreement during which the seller will be obliged to pay a commission if anyone brought to the seller by the broker, or a cooperating broker, during the listing term buys the property. The broker should give the names of such prospective buyers to the seller within 3 calendar days of termination of the contract. California_E_Principles_10E_book.int 146 the 23rd of May 2017 2:27 and 1 p.m. Unit 6 The Law of Agency 147 Other clauses provide for the broker's compensation in the event of a property exchange, the seller's default, or the default of anyone other than the seller. In Section 3D, the broker is authorized to cooperate with other brokers through the MLS or otherwise. In Section 3E, the seller agrees to pay the broker's compensation through escrow. Section 3F provides for compensation to a broker with whom the seller has previously listed the property, if the name of the buyer is identified in this section. 4A. The contract should stipulate any fixtures the owner is excluding or personal property, such as furniture, the owner is including in the sale. 4B. Indicate any items on the property that are leased, such as a water softener, solar system, or alarm system. 5. The broker is authorized to use the MLS unless the seller gives written authorization to exclude the listing from the MLS in a separate form. The seller can exclude the property from display on internet sites or electronic displays of MLS participants and subscribers, but that exclusion may not limit access to property information made available by other internet sites that are not under the control of the MLS. 6. Seller knows of no loan delinquency, bankruptcy, or other legal action that would affect the property or its transfer. 7. The broker promises to use reasonable effort and act with due diligence to find a buyer for the listed property. The broker is authorized to advertise and market the property. The seller promises to consider all offers presented by the broker and to act in good faith. The seller agrees to indemnify the broker, including paying the broker's legal fees, in the event of a dispute stemming from any incorrect information supplied by the seller. 8. The broker is authorized to accept a buyer's deposit for the seller. 9. The seller will receive an agency disclosure form. The broker will act as agent of the seller. Any other agency relationship requires agreement of seller and broker. Seller agrees that broker can act as a dual agent in procuring a buyer. 10. It is the seller's responsibility to insure and protect household belongings while the property is listed for sale. 11. The seller may or may not give the broker permission to use electronic images of the property, but the seller acknowledges that the broker cannot control the taking of property photographs by prospective buyers or other persons. 12. The seller may or may not allow the use of a lockbox attached outside the house, with the house key inside, accessible to brokers. 13. The seller may or may not allow a for sale or sold sign on the property. 14. An anti-discrimination clause is evidence of the parties' intent to obey all applicable laws. 148 California Real Estate Principles 10th edition. 15. Both broker and seller are made aware that if a legal action ensues, reasonable attorney's fees and other costs will be awarded to the successful party. 16. The listing agreement may be subject to lender requirements if the property is lender-owned, RO, or is being sold for less than the remaining loan balance, short sale. Any other items not already covered can be mentioned here, such as repairs to be made by the seller. This is also the place to mention any potential buyers the seller has already contacted with whom the seller wishes to deal without paying the broker a commission. 17. If an associate licensee signs the contract on behalf of the broker or the broker's manager has a 5-day right of cancellation. 18. The contract can be assigned. 19. The broker and seller agree to submit any differences of opinion to mediation before going through a formal arbitration process or beginning legal action in court subject to the exceptions noted in this clause. The broker and seller may agree to submit their differences, if any, to binding arbitration, except as the clause specifies. Note: in 2005, the California Supreme Court held in Grafton Partners v. Superior Court that any pre-dispute contractual waiver of the right to a jury trial is constitutionally invalid. 20. The agreement incorporates any prior understanding of the broker and seller, whether written or oral. 21. The seller must indicate that she owns the property and any other ownership interest, if applicable. California_E_Principles_10E_book.int 148 May 2017 2:27 and 1 p.m. Unit 6 The Law of Agency 149 Figure 6.4 Exclusive Authorization and Right to Sell Listing. Sample CALIFORNIOAS Association of Realtors A Registered Residential Listing Agreement. Exclusive Authorization and Right to Sell, CAR, Form RLA, Revised 1215. Residential Listing Agreement, Exclusive, RLA Page 1 of 5. RLA Revised 1215, Page 1 of 5. Print date A Copyright 2015, California Association of Realtors A Registered, Incorporated. Seller's initials, __, date prepared, _1. Exclusive right to sell, seller, hereby employs and grants _broker, beginning, date, and ending at 11:59 p.m. on, date, listing period. The exclusive and irrevocable right to sell or exchange the real property described as situated in city, county, California, zip code, assessor's parcel number, property. This property is a manufactured, mobile, home. See addendum for additional terms. This property is being sold as part of a probate, conservatorship or guardianship. See addendum for additional terms. 2. Listing price and terms. A. The listing price shall be $, B. Listing terms, __. 3. Compensation to broker. Notice, the amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. Real estate commissions include all compensation and fees to broker. A. Seller agrees to pay to broker as compensation for services irrespective of agency relationships, either % of the listing price, or if a purchase agreement is entered into, of the purchase price, or $, and as follows. 1. If during the listing period, or any extension, broker, cooperating broker, seller or any other person procures a ready, willing, and able buyers whose offer to purchase the property on any price and terms is accepted by seller, provided the buyer completes the transaction or is prevented from doing so by seller. Broker is entitled to compensation whether any escrow resulting from such offer closes during or after the expiration of the listing period, or any extension, or 2, if within calendar days, A. After the end of the listing period or any extension, or B. After any cancellation of this agreement, unless otherwise agreed. Seller enters into a contract to sell, convey, lease or otherwise transfer the property to anyone, prospective buyer, or that person's related entity, I, who physically entered and was shown the property during the listing period or any extension by broker or a cooperating broker, or 2, for whom broker or any cooperating broker submitted to seller a signed, written offer to acquire, lease, exchange or obtain an option on the property. Seller, however, shall have no obligation to broker under paragraph 3A2 unless, not later than the end of the listing period or any extension or cancellation, broker has given seller a written notice of the names of such prospective buyers, or 3, if, without broker's prior written consent, the property is withdrawn from sale, conveyed, leased, rented, otherwise transferred, or made unmarketable by a voluntary act of seller during the listing period, or any extension. B. If completion of the sale is prevented by a party to the transaction other than seller, then compensation which otherwise would have been earned under paragraph 3A shall be payable only if and when seller collects damages by suit, arbitration, settlement or otherwise, and then in an amount equal to the lesser of 1/2 of the damages recovered or the above compensation, after first deducting title and escrow expenses and the expenses of collection, if any. C. In addition, seller agrees to pay broker, D. Seller has been advised of broker's policy regarding cooperation with, and the amount of compensation offered to, other brokers. 1. Broker is authorized to cooperate with and compensate brokers participating through the Multiple Listing Services, MLS, by offering to MLS brokers out of brokers compensation specified in 3A, either %% of the purchase price, or $_2. Broker is authorized to cooperate with and compensate brokers operating outside the MLS as per broker's policy. Seller hereby irrevocably assigns to broker the above compensation from seller's funds and proceeds in escrow. Broker may submit this agreement, as instructions to compensate broker pursuant to paragraph 3A, to any escrow regarding the property involving seller and a buyer, prospective buyer or other transferee. F1. Seller represents that seller has not previously entered into a listing agreement with another broker regarding the property, unless specified as follows. _2. Seller warrants that seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the following individuals or entities. _3. If the property is sold to anyone listed above during the time seller is obligated to compensate another broker, broker is not entitled to compensation under this agreement, and 2. Broker is not obligated to represent seller in such transaction. 4a. Items excluded and included, unless otherwise specified in a real estate purchase agreement. All fixtures and fittings that are attached to the property are included, and personal property items are excluded from the purchase price. Additional items excluded, additional items included, Source, reprinted with permission, California Association of Realtors. A registered endorsement not implied. California _E_ principles _10E_ book.int 149 the 23rd of May 2017 2:27 and 4 seconds p.m. 150 California Real Estate Principles 10th edition figure 6.4, exclusive authorization and right to sell listing. Continued. Sample property address :_date :_seller intends that the above items be excluded or included in offering the property for sale, but understands that the purchase agreement supersedes any intention expressed above and will ultimately determine which items are excluded and included in the sale, and 2. Broker is not responsible for and does not guarantee that the above exclusions and/or inclusions will be in the purchase agreement. B1. Leased items. The following items are leased: solar power system, alarm system, propane tank, water softener, other _2. Land items. The following items have been financed and a lien has been placed on the property to secure payment: solar power system, windows or doors, heating/ventilation/air conditioning system. Other _seller will provide to buyer, as part of the sales agreement, copies of lease documents, or other documents obligating seller to pay for any such leased haul and item. 5. Multiple listing service. A broker is a participant, subscriber to _multiple listing service, MLS, and possibly others. Unless otherwise instructed in writing, the property will be listed with the MLSs specified above. That MLS is, or if checked is not, the primary MLS for the geographic area of the property. All terms of the transaction, including sales price and financing, if applicable, will be provided to the MLS in which the property is listed for publication, dissemination and use by persons and entities on terms approved by the MLS, and 2. May be provided to the MLS even if the property was not listed with the MLS. Benefits of using the MLS: impact of opting out of the MLS, presenting all offers. What is an MLS? The MLS is a database of properties for sale that is available and disseminated to and accessible by all other real estate agents who are participants or subscribers to the MLS. Property information submitted to the MLS describes the price, terms and conditions under which the seller's property is offered for sale, including but not limited to the listing broker's offer of compensation to other brokers. It is likely that a significant number of real estate practitioners in any given area are participants or subscribers to the MLS. The MLS may also be part of a reciprocal agreement to which other multiple listing services belong. Real estate agents belonging to other multiple listing services that have reciprocal agreements with the MLS also have access to the information submitted to the MLS. The MLS may further transmit listing information to internet sites that post property listings online. Exposure to buyers through MLS. Listing property with an MLS exposes a seller's property to all real estate agents and brokers, and their potential buyer clients, who are participants or subscribers to the MLS or a reciprocating MLS. Closed, private listing clubs or groups. Closed or private listing clubs or groups are not the same as the MLS. The MLS referred to above is accessible to all eligible real estate licensees and provides broad exposure for a listed property. Private or closed listing clubs or groups of licensees may have been formed outside the MLS. Private or closed listing clubs or groups are accessible to a more limited number of licensees and generally offer less exposure for listed property. Whether listing property through a closed, private network, and excluding it from the MLS, is advantageous or disadvantageous to a seller, and why, should be discussed with the agent taking the seller's listing. Not listing property in a local MLS. If the property is listed in an MLS which does not cover the geographic area where the property is located, then real estate agents and brokers working that territory, and buyers they represent looking for property in the neighborhood, may not be aware the property is for sale. Opting out of MLS. If seller elects to exclude the property from the MLS, seller understands and acknowledges that a. real estate agents and brokers from other real estate offices, and their buyer clients, who have access to that MLS may not be aware that seller's property is offered for sale. B. Information about seller's property will not be transmitted from the MLS to various real estate internet sites that are used by the public to search for property listings. C. Real estate agents, brokers and members of the public may be unaware of the terms and conditions under which seller is marketing the property. Reduction in exposure. Any reduction in exposure of the property may lower the number of offers and negatively impact the sales price. Presenting all offers. Seller understands that broker must present all offers received for seller's property unless seller gives broker written instructions to the contrary. B. MLS rules generally provide that residential real property and vacant lot listings be submitted to the MLS within 2 days or some other period of time after all necessary signatures have been obtained on the listing agreement. Broker will not have to submit this listing to the MLS if, within that time, broker submits to the MLS an appropriate form signed by seller. Seller elects to exclude the property from the MLS as provided by CAR. Form SELM or the local equivalent form. RLA revised 1215, page 2 of 5. Residential listing agreement. Exclusive, RLA page 2 of 5. Seller's initials, _, seller's initials, _, broker '/agent's initials, _, source, reprinted with permission, California Association of Realtors. A registered endorsement not implied. California _E principles _10E book.int 150 the 23rd of May 2017 2:27 and 5 seconds p.m. Unit 6 The Law of Agency 151 Figure 6.4 Exclusive authorization and right to sell listing. Continued. Sample property address :_date :_c. MLS rules allow MLS data to be made available by the MLS to additional internet sites unless broker gives the MLS instructions to the contrary. Seller acknowledges that for any of the below opt-out instructions to be effective, seller must make them on a separate instruction to broker signed by seller. Specific information that can be excluded from the internet as permitted by, or in accordance with, the MLS is as follows. 1. Property availability. Seller can instruct broker to have the MLS not display the property on the internet. 2. Property address. Seller can instruct broker to have the MLS not display the property address on the internet. Seller understands that the above opt-outs would mean consumers searching for listings on the internet may not see the property or property's address in response to their search. 3. Feature opt-outs. Seller can instruct broker to advise the MLS that seller does not want visitors to MLS participant or subscriber websites or electronic displays that display the property listing to have the features below. Seller understands, that these opt-outs apply only to websites or electronic displays of MLS participants and subscribers who are real estate broker and agent members of the MLS. 2. That other internet sites may or may not have the features set forth herein, and 3. That neither broker nor the MLS may have the ability to control or block such features on other internet sites. A. Comments and reviews. The ability to write comments or reviews about the property on those sites, or the ability to link to another site containing such comments or reviews if the link is in immediate conjunction with the property display. B. Automated estimate of value. The ability to create an automated estimate of value or to link to another site containing such an estimate of value if the link is in immediate conjunction with the property display. Seller elects to opt out of certain internet features as provided by CAR Form SELI or the local equivalent form. 6. Seller representations. Seller represents that, unless otherwise specified in writing, seller is unaware of any notice of default recorded against the property. 2. Any delinquent amounts due under any loan secured by, or other obligation affecting, the property. 3. Any bankruptcy, insolvency or similar proceeding affecting the property. 4. Any litigation, arbitration, administrative action, government investigation or other pending or threatened action that affects or may affect the property or seller's ability to transfer it, and v. Any current, pending or proposed special assessments affecting the property. Seller shall promptly notify broker in writing if seller becomes aware of any of these items during the listing period or any extension thereof. 7. Brokers and sellers' duties. A. Broker agrees to exercise reasonable effort and due diligence to achieve the purposes of this agreement. Unless seller gives broker written instructions to the contrary, broker is authorized, but not required, 2. Order reports and disclosures including those specified in 7C as necessary. 2. Advertise and market the property by any method and in any medium selected by broker, including MLS and the Internet, and, to the extent permitted by these media, control the dissemination of the information submitted to any medium, and 3. Disclose to any real estate licensee making an inquiry the receipt of any offers on the property and the offering price of such offers. B. Seller agrees to consider offers presented by broker, and to act in good faith to accomplish the sale of the property by, among other things, making the property available for showing at reasonable times and, subject to paragraph 4F, referring to broker all inquiries of any party interested in the property. Seller is responsible for determining at what price to list and sell the property. C. Investigations and reports. Seller agrees, within 5, days of the beginning date of this agreement, to pay for the following pre-sale reports: structural pest control, general property inspection, homeowners association documents, other D. Seller further agrees to indemnify, defend and hold broker harmless from all claims, disputes, litigation, judgments, attorney fees and costs arising from any incorrect or incomplete information supplied by seller, or from any material facts that seller knows but fails to disclose. 8. Deposit. Broker is authorized to accept and hold on seller's behalf any deposits to be applied toward the purchase price. 9. Agency relationships. A. Disclosure. The seller acknowledges receipt of a disclosure regarding real estate agency relationships. CAR Form Ad. B. Seller representation. Broker shall represent seller in any resulting transaction, except as specified in paragraph 3F. C. Possible dual agency with buyer. Depending upon the circumstances, it may be necessary or appropriate for broker to act as an agent for both seller and buyer, exchange party, or one or more additional parties. Buyer. Broker shall, as soon as practicable, disclose to seller any election to act as a dual agent representing both seller and buyer. If a buyer is procured directly by broker or an associate licensee in broker's firm, seller hereby consents to broker acting as a dual agent for seller and buyer. In the event of an exchange, seller hereby consents to broker collecting compensation from additional parties for services rendered, provided there is disclosure to all parties of such agency and compensation. Seller understands and agrees that, I, broker, without the prior written consent of seller, will not disclose to buyer that seller is willing to sell the property at a price less than the listing price. 2. Broker, without the prior written consent of buyer, will not disclose to seller that buyer is willing to pay a price greater than the offered price. And 3. Except for I, and 2, above, a dual agent is obligated to disclose known facts materially affecting the value or desirability of the property to both parties. D. Confirmation. If the property includes residential property with 1 to 4 dwelling units, broker shall confirm the agency relationship described above, or as modified, in writing, prior to or concurrent with seller's execution of a purchase agreement. E. Potentially competing sellers and buyers. Seller understands that broker may have or obtain listings on other properties, and that potential buyers may consider, make offers on, or purchase through broker, property the same as or similar to seller's property. Seller consents to broker's representation of sellers and buyers of other properties before, during and after the end of this agreement. Seller acknowledges receipt of a possible representation of more than one buyer or seller. Disclosure and consent. CAR Form PRBS, RLA Revised 1215, page 3 of 5, seller's initials, __, residential listing agreement, exclusive, RLA page 3 of 5. 44. Source, reprinted with permission, California Association of Realtors. A registered endorsement not implied. California _E_ principles _10E_ book.int 151 the 23rd of May 2017 2:27 and 5 seconds p.m. 152 California Real Estate Principles 10th edition figure 6.4, exclusive authorization and right to sell listing, continued. Sample property address, _date : residential listing agreement, exclusive, RLA page 4 of 5, RLA revised 1215, page 4 of 5. 10. Security and insurance. Broker is not responsible for loss of or damage to personal or real property, or person, whether attributable to use of a Keysafe Lockbox, a showing of the property, or otherwise. Third parties, including, but not limited to, appraisers, inspectors, brokers and prospective buyers, may have access to, and take videos and photographs of, the interior of the property. Seller agrees, I, to take reasonable precautions to safeguard and protect valuables that might be accessible during showings of the property, and 2, to obtain insurance to protect against these risks. Broker does not maintain insurance to protect seller. 11. Photographs and Internet advertising. A. In order to effectively market the property for sale, it is often necessary to provide photographs, virtual tours and other media to buyers. Seller agrees, or if checked, does not agree, that broker may photograph or otherwise electronically capture images of the exterior and interior of the property, images, for static and or virtual tours of the property by buyers and others for use on broker's website, the MLS, and other marketing materials and sites. Seller acknowledges that once images are placed on the internet, neither broker nor seller has control over who can view such images and what use viewers may make of the images, or how long such images may remain available on the internet. Seller further assigns any rights in all images to the broker and agrees that such images are the property of broker and that broker may use such images for advertising, including post-sale and for broker's business in the future. B. Seller acknowledges that prospective buyers and or other persons coming onto the property may take photographs, videos or other images of the property. Seller understands that broker does not have the ability to control or block the taking and use of images by any such persons. If checked, Seller instructs broker to publish in the MLS that taking of images is limited to those persons preparing appraisal or inspection reports. Seller acknowledges that unauthorized persons may take images who do not have access to or have not read any limiting instruction in the MLS, or who take images regardless of any limiting instruction in the MLS. Once images are taken and/or put into electronic display on the internet or otherwise, neither broker nor seller has control over who views such images nor what use viewers may make of the images. 12. Keysafe/Lockbox. A Keysafe Lockbox is designed to hold a key to the property to permit access to the property by broker, cooperating brokers, MLS participants, their authorized licensees and representatives, authorized inspectors, and accompanied prospective buyers. Broker, cooperating brokers, MLS and associations, boards of realtors, registered are not insurers against injury, theft, loss, vandalism or damage attributed to the use of a Keysafe Lockbox. Seller does, or if checked does not, authorize broker to install a Keysafe Lockbox. If seller does not occupy the property, seller shall be responsible for obtaining occupant's written permission for use of a Keysafe Lockbox. CAR Form KLA. 13. Sign. Seller does, or if checked does not, authorize broker to install a for sale, sold sign on the property. 14. Equal housing opportunity. The property is offered in compliance with federal, state and local anti-discrimination laws. 15. Attorney fees. In any action, proceeding or arbitration between seller and broker regarding the obligation to pay compensation under this agreement, the prevailing seller or broker shall be entitled to reasonable attorney fees and costs from the non-prevailing seller or broker, except as provided in paragraph 19A. 16. Additional terms. ____________ 17. Management approval. If an associate licensee in broker's office, salesperson or broker associate, enters into this agreement on broker's behalf, and broker or manager does not approve of its terms, broker or manager has the right to cancel this agreement, in writing, within 5 days after its execution. 18. Successors and assigns. This agreement shall be binding upon seller and seller's successors and assigns. 19. Dispute resolution. Mediation. Seller and broker agree to mediate any dispute or claim arising between them regarding the obligation to pay compensation under this agreement, before resorting to arbitration or court action. Mediation fees, if any, shall be divided equally among the parties involved. If, for any dispute or claim to which this paragraph applies, any party, commences an action without first attempting to resolve the matter through mediation, or, 2, before commencement of an action, refuses to mediate after a request has been made, then that party shall not be entitled to recover attorney fees, even if they would otherwise be available to that party in any such action. This mediation provision applies whether or not the arbitration provision is initialed. Exclusions from this mediation agreement are specified in paragraph 19c. B. Arbitration of disputes. Seller and broker agree that any dispute or claim in law or equity arising between them regarding the obligation to pay compensation under this agreement, which is not settled through mediation, shall be decided by a neutral, binding arbitration. The arbitrator shall be a retired judge or justice, or an attorney with at least 5 years of residential real estate law experience, unless the parties mutually agree to a different arbitrator. The parties shall have the right to discovery in accordance with Code of Civil Procedure A Section 1283.05. In all other respects, the arbitration shall be conducted in accordance with Title 9 of Part 3 of the Code of Civil Procedure. Judgment upon the award of the arbitrators may be entered into any court having jurisdiction. Enforcement of this agreement to arbitrate shall be governed by the Federal Arbitration Act. Exclusions from this arbitration agreement are specified in paragraph 19c. Row advisory listing, CAR Form Real, short sale information and advisory, CAR Form SIA, seller's initials, ___, trust advisory, CAR Form DAL. Source, reprinted with permission, California Association of Realtors A registered. Endorsement not implied. California_E_principles_10E_book.int 152 the 23rd of May 2017 2:27 p.m. Unit 6 The Law of Agency 153 Figure 6.4 Exclusive Authorization and Right to Sell Listing Continued. Sample property address: :date: notice. By initialing in the space below, you are agreeing to have any dispute arising out of the matters included in the arbitration of disputes provision decided by neutral arbitration as provided by California law, and you are giving up any rights you might possess to have the dispute litigated in a court. 154 California Real Estate Principles 10th edition. The date of signing is given, and the seller signs. If an owner is married, even if the real estate is the seller's separate property, the other spouse's signature should also be obtained, either directly or through a power of attorney. The correct address of the sellers and other contact information are also important. The broker signs and dates the contract. If an associate licensee initiates the contract, the associate signs her name next to the name of the broker or firm. Their firm's mailing address and other contact information is provided. In completing a listing agreement, the real estate agent will be guiding the property owner through a legally binding contract. Yet the agent is not permitted to give legal advice. If the owner is confused about the meaning or ramifications of any of the contract terms, the agent should recommend in writing that the owner consult an attorney before signing. Buyer broker agreements: the real estate broker does not always represent the property seller. Increasingly, property buyers are recognizing the important advantages that can be obtained by having their own broker represent them in a transaction. As with other real estate contracts, the terms under which the buyer's broker will function must be specified in writing. Figure 6.5 is a typical form of buyer-broker agreement. Note the following contract clauses. A. Clause 1A specifies the type of property the buyer is seeking. A. Clause 2C1 states the limitations on the broker in a possible dual agency representation. A. Clause 2D provides for the buyer's acceptance of the broker's representation of other buyers seeking the same or similar properties. A. Clause 3 stipulates the type of compensation to be paid to the broker. This could be a fee to be paid to the broker, based on a stated amount or percentage of the purchase price of the property. Provision is made for compensating the broker in the event that the buyer enters into an agreement to purchase property that the broker introduced to the buyer, so long as the agreement is entered into within the specified number of days of their expiration of the representation period. The terms under which compensation is to be paid are stated, as is the fact that any compensation that the buyer's broker collects from anyone other than the buyer is to be credited against the fee due from the buyer. A. Clause 4 explains that the broker has no control over comments or postings on the internet regarding properties that have been shown to the buyer. California_E_principles_10E_book.int 154 the 23rd of May 2017 2:27 p.m. Unit 6 The Law of Agency 155 Figure 6.5 Exclusive right to represent buyer. Sample California as Association of Realtors A registered buyer representation agreement. Exclusive CAR Form BRE Revised 413 Buyer Representation Agreement A Exclusive BRE Page 1 of 4 BRE Revised 413 Page 1 of 4 Print date A Copyright 2012 California Association of Realtors A Registered Incorporated Buyer's initials __ reviewed by _date _1 Exclusive right to represent _buyer grants _broker beginning on date _ and ending at I:11:59 p.m. on date _ 2 completion of a resulting transaction, whichever occurs first. Representation period, the exclusive and irrevocable right, on the terms specified in this agreement, to represent buyer in acquiring real property or a manufactured home as follows. A. Property to be acquired. 1. Any purchase, lease or other acquisition of any real property or manufactured home described as location: $_other $_price range, $_ to $_ or 2. The following specified properties only: $_ or 3. Only the properties identified on the attached list. B. Broker agrees to exercise due diligence and reasonable efforts to fulfill the following authorizations and obligations. C. Broker will perform its obligations under this agreement through the individual signing for broker below or another real estate licensee assigned by broker, who is either broker individually or an associate licensee, an individual licensed as a real estate salesperson, or broker who works under broker's real estate license. Buyer agrees that broker's duties are limited by the terms of this agreement, including those limitations set forth in paragraphs 5 and 6. 2. Agency relationships. A. Disclosure. If the property described in paragraph 4 includes residential property with 1 to 4 dwelling units, buyer acknowledges receipt of the disclosure regarding real estate agency relationships, CAR Form AD, prior to entering into this agreement. B. Buyer representation. Broker will represent, as described in this agreement, buyer in any resulting transaction. C. 1. Possible dual agency with seller. C1 applies unless C2I or 2 is checked below. Depending on the circumstances, it may be necessary or appropriate for broker to act as an agent for both buyer and a seller, exchange party, or one or more additional parties. Seller. Broker shall, as soon as practicable, disclose to buyer any election to act as a dual agent representing both buyer and seller. If buyer is shown property listed with broker, buyer consents to broker becoming a dual agent representing both buyer and seller with respect to those properties. In event of dual agency, buyer agrees that a. Broker, without the prior written consent of buyer, will not disclose to seller that the buyer is willing to pay a price greater than the price offered. B. Broker, without the prior written consent of seller, will not disclose to buyer that seller is willing to sell property at a price less than the listing price, and c. other than as set forth in A and B above. A dual agent is obligated to disclose known facts materially affecting the value or desirability of the property to both parties. Or 2. Single agency only applies only if I or 2 is checked below. I. Broker's firm lists properties for sale. Buyer understands that this election will prevent broker from showing buyer those properties that are listed with broker's firm or from representing buyer in connection with those properties. Buyer's acquisition of a property listed with broker's firm shall not affect broker's right to be compensated under paragraph 3. In any resulting transaction in which seller's property is not listed with broker's firm, broker will be the exclusive agent of buyer and not a dual agent also representing seller. Or 2. Broker's firm does not list property. Entire brokerage firm only represents buyers and does not list property. In any resulting transaction, broker will be the exclusive agent of buyer and not a dual agent also representing seller. D. Other potential buyers. Buyer understands that other potential buyers may, through broker, consider, make offers on or acquire the same or similar properties as those buyer is seeking to acquire. Buyer consents to broker's representation of such other potential buyers before, during and after the representation period, or any extension thereof. E. Non-confidentiality of offers. Buyer is advised that seller or listing agent may disclose the existence, terms, or conditions of buyer's offer unless all parties and their agent have signed a written confidentiality agreement. Whether any such information is actually disclosed depends on many factors, such as current market conditions, the prevailing practice in the real estate community, the listing agent's marketing strategy and the instructions of the seller. F. Confirmation. If the property, as defined below, includes residential property with 1 to 4 dwelling units, broker shall confirm the agency relationship described above, or as modified, in writing, prior to or coincident with buyer's execution of a property contract, as defined below. 3. Compensation to broker. Notice, The amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between buyer and broker. Real estate commissions include all compensation and fees to broker. Buyer agrees to pay to broker, irrespective of agency relationships, as follows. A. Amount of compensation. Check 1, 2, or 3. Check only 1% of the acquisition price and, if checked, $, or $2, or 3, pursuant to the compensation schedule attached as an addendum _. Source, reprinted with permission, California Association of Realtors. A registered endorsement not implied. California _E principles _10E book.int 155 the 23rd of May 2017 2:27 and 8 seconds p.m. 156 California Real Estate Principles 10th edition figure 6.5 exclusive right to represent buyer continued. Sample buyer _date BRE revised 413, page 2 of 4. Reviewed by _date buyer representation agreement A exclusive, BRE page 2 of 4. B. Compensation payments and credits. Buyer is responsible for payment of compensation provided for in this agreement. However, if anyone other than buyer compensates broker for services covered by this agreement, that amount shall be credited toward buyer's obligation to pay compensation. If the amount of compensation broker receives from anyone other than buyer exceeds buyer's obligation, the excess amount shall be disclosed to buyer and if allowed by law paid to broker, or, if checked, A credited to buyer, or A other _ C. Broker right to compensation. Broker shall be entitled to the compensation provided for in paragraph 3A, 1. If during the representation period, or any extension thereof, buyer enters into an agreement to acquire property described in paragraph 1A, on terms acceptable to buyer provided seller completes the transaction or is prevented from doing so by buyer, broker shall be entitled to compensation whether any escrow resulting from such agreement closes during or after the expiration of the representation period. 2. If, within calendar days after expiration of the representation period or any extension thereof, buyer enters into an agreement to acquire property described in paragraph 1, which property broker introduced to buyer, or for which broker acted on buyer's behalf. The obligation to pay compensation pursuant to this paragraph shall arise only if, prior to or within 3, or A _ calendar days after expiration of this agreement or any extension thereof, broker gives buyer a written notice of those properties which broker introduced to buyer, or for which broker acted on buyer's behalf. D. Timing of compensation. Compensation is payable, 1. Upon completion of any resulting transaction, and if an escrow is used, through escrow. 2. If acquisition is prevented by default of buyer, upon buyer's default. 3. If acquisition is prevented by a party to the transaction other than buyer, when buyer collects damages by suit, settlement or otherwise. Compensation shall equal 1/2 of the damages recovered, not to exceed the compensation provided for in paragraph 3A, after first deducting the unreimbursed payments, credits and expenses of collection, if any. E. Buyer hereby irrevocably assigns to broker the compensation provided for in paragraph 3A from buyer's funds and proceeds in escrow. Buyer agrees to submit to escrow any funds needed to compensate broker under this agreement. Broker may submit this agreement, as instructions to compensate broker, to any escrow regarding property involving buyer and a seller or other transferor. F. Buyer includes any person or entity, other than broker, related to buyer or who in any manner acts on buyer's behalf to acquire property described in paragraph 1AG. 1. Buyer has not previously entered into a representation agreement with another broker regarding property described in paragraph 1A, unless specified as follows. Name other broker here, __. 2. Buyer warrants that buyer has no obligation to pay compensation to any other broker regarding property described in paragraph 1A, unless buyer acquires the following property: 3. If buyer acquires a property specified in G2 above during the time buyer is obligated to compensate another broker, broker is neither I. entitled to compensation under this agreement, nor 2. obligated to represent buyer in such transaction. 4. Internet advertising, internet blogs, social media. Buyer acknowledges and agrees that I. properties presented to them may have been marketed through a virtual tour on the internet, permitting potential buyers to view properties over the internet, or that the properties may have been the subject of comments or opinions of value by others on internet blogs or other social media sites. 2. Neither the service providers nor broker has control over who will obtain access to such services or what action such persons might take, and 3. Broker has no control over how long the information concerning the properties will be available on the internet or social media sites. 5. Broker authorizations and obligations. A. Buyer authorizes broker to I. locate and present selected properties to buyer, present offers authorized by buyer, and assist buyer in negotiating for acceptance of such offers. 2. Assist buyer with the financing process, including obtaining loan pre-qualification. 3. Upon request, provide buyer with a list of professionals or vendors who perform the services described in their attached buyer's inspection advisory. 4. Order reports, and schedule and attend meetings and appointments with professionals chosen by buyer. V. Provide guidance to help buyer with the acquisition of property, and vi. Obtain a credit report on buyer. B. For property transactions of which broker is aware and not precluded from participating in by buyer, broker shall provide and review forms to create a property contract, for the acquisition of a specific property. With respect to such property, broker shall, I. If the property contains residential property with 1 to 4 dwelling units, conduct a reasonably competent and diligent on-site visual inspection of the accessible areas of the property, excluding any common areas, and disclose to buyer all facts materially affecting the value or desirability of such property that are revealed by this inspection. 2. Deliver or communicate to buyer any disclosures, materials or information received by, in the personal possession of or personally known to the individual signing for broker below during the representation period. And 3. Facilitate the escrow process, including assisting buyer in negotiating with seller. Unless otherwise specified in writing, any information provided through broker in the course of representing buyer has not been and will not be verified by broker. Broker's services are buyer's initials, __, source, reprinted with permission, California Association of Realtors, a registered endorsement not implied, California _E_ principles _10E_ book.int 156 the 23rd of May 2017 2:27 and 8 seconds p.m. Unit 6 The Law of Agency 157 Figure 6.5 Exclusive right to represent buyer, continued. Sample buyer, _date. BRE revised 413, page 3 of 4, reviewed by _date _buyer representation agreement A exclusive, BRE page 3 of 4, performed in compliance with federal, state and local anti-discrimination laws. 6. Scope of broker duty. A. While broker will perform the duties described in paragraph 6b, broker recommends that buyer select other professionals, as described in the attached buyer's inspection advisory, to investigate the property through inspections, investigations, tests, surveys, reports, studies and other available information. Inspections, during the transaction. Buyer agrees that these inspections, to the extent they exceed the obligations described in paragraph 6b, are not within the scope of broker's agency duties. Broker informs buyer that it is in buyer's best interest to obtain such inspections. B. Buyer acknowledges and agrees that broker, I, does not decide what price buyer should pay or seller should accept. 2. Does not guarantee the condition of the property. 3. Does not guarantee the performance, adequacy or completeness of inspections, services, products or repairs provided or made by seller or others. 4. Does not have an obligation to conduct an inspection of common areas or off-site areas of the property. V. shall not be responsible for identifying defects on the property, in common areas or off-site unless such defects are visually observable by an inspection of reasonably accessible areas of the property or are known to broker. Vi. Shall not be responsible for inspecting public records or permits concerning the title or use of the property. 7. Shall not be responsible for identifying the location of boundary lines or other items affecting title. 8. Shall not be responsible for verifying square footage, representations of others or information contained in investigation reports, multiple listing service, advertisements, flyers or other promotional material. 9. Shall not be responsible for providing legal or tax advice regarding any aspect of a transaction entered into by buyer or seller, and X. Shall not be responsible for providing other advice or information that exceeds the knowledge, education and experience required to perform real estate licensed activity. Buyer agrees to seek legal, tax, insurance, title and other desired assistance from appropriate professionals. C. Broker owes no duty to inspect for common environmental hazards, earthquake weaknesses, or geologic and seismic hazards. If buyer receives the booklets titled Environmental Hazards, a guide for homeowners, buyers, landlords and tenants, the Homeowner's Guide to Earthquake Safety, or the Commercial Property Owner's Guide to Earthquake Safety, the booklets are deemed adequate to inform buyer regarding the information contained in the booklets and, other than as specified in 6b above, broker is not required to provide buyer with additional information about the matters described in the booklets. 7. Buyer obligations. A. Buyer agrees to timely view and consider properties selected by broker and to negotiate in good faith to acquire a property. Buyer further agrees to act in good faith toward the completion of any property contract entered into in furtherance of this agreement. Within 5, or a_ calendar days from the execution of this agreement, buyer shall provide relevant personal and financial information to broker to assure buyer's ability to acquire property described in paragraph 4. If buyer fails to provide such information, or if buyer does not qualify financially to acquire property described in paragraph 4, then broker may cancel this agreement in writing. Buyer has an affirmative duty to take steps to protect him, herself, including discovery of the legal, practical and technical implications of discovered or disclosed facts, an investigation of information and facts which are known to buyer or are within the diligent attention and observation of buyer. Buyer is obligated, and agrees, to read all documents provided to buyer. Buyer agrees to seek desired assistance from appropriate professionals, selected by buyer, such as those referenced in the attached buyer's inspection advisory. B. Buyer shall notify broker in writing, CAR Form BMI, of any material issue to buyer, such as, but not limited to, buyer requests for information on, or concerns regarding, any particular area of interest or importance to buyer, material issues. C. Buyer agrees to, I. Indemnify, defend and hold broker harmless from all claims, disputes, litigation, judgments, costs and attorney fees arising from any incorrect information supplied by buyer, or from any material issues that buyer fails to disclose in writing to broker, and 2. Pay for reports, inspections and meetings arranged by broker on buyer's behalf. D. Buyer is advised to read the attached buyer's inspection advisory for a list of items and other concerns that typically warrant inspections or investigation by buyer or other professionals. 8. Other terms and conditions. The following disclosures or addenda are attached: A. A_B, A_C, A_D, A_9. Attorney fees, in any action, proceeding or arbitration between buyer and broker regarding the obligation to pay compensation under this agreement. The prevailing buyer or broker shall be entitled to reasonable attorney fees and costs, except as provided in paragraph 11a. 10. Entire agreement. All understandings between the parties are incorporated in this agreement. Its terms are intended by the parties as a final, complete and exclusive expression of their agreement with respect to its subject matter, and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. This agreement may not be extended, amended, modified, altered or changed, except in writing signed by buyer and broker. In the event that any provision of this agreement is held to be ineffective or invalid, the remaining provisions will nevertheless be given full force and effect. This agreement and any supplement, addendum or modification, including any copy, whether by copier, facsimile, NCR or electronic, may, buyer's initials, __, buyer's inspection advisory, CAR Form Buyer B, statewide buyer and seller advisory, CAR Form SBSA, source, reprinted with permission, California Association of Realtors. A registered endorsement not implied. California _E_ principles _10E_ book. 157 the 23rd of May 2017 2:27 and 9 seconds p.m. 158 California Real Estate Principles 10th edition figure 6.5, exclusive right to represent buyer, continued. Sample buyer, date, buyer representation agreement A exclusive, BRE page 4 of 4, 159. Rights and duties of principal and agent. Both parties to an agency agreement have obligations. An obligation owed by one party is a corresponding right of the other party. The agent has the obligation to use due diligence in fulfilling the purpose of the agency agreement. This obligation also may be expressed as the right of the principal to have the agent use such diligence. This section examines the duties each owes the other and the consequences of any failure by either to perform those duties. Duties of agent to principal. One of the most important duties the agent owes the principal is the duty of loyalty. The agent in a real estate transaction acts as a fiduciary, a person to whom property or the power to act is entrusted on behalf of someone else. The agent's role in the transaction is to consider the interests of the principal first and foremost. The agent's fulfillment of the duties of good faith and honesty will allow the agent to fairly represent the principal's interests. The agent must respect the confidentiality of personal information made known to the agent by the principal. This duty extends to computerized data compiled or obtained in the course of business. Civil Code Section 1798.29 requires notification to any resident of California in the event of a breach of such data. The notice of data breach must follow the prescribed statutory format, to the extent required by their agreement. The agent owes the principal the duty of obedience in relevant matters. The principal cannot obstruct the agent's activities but can direct the agent generally. For example, a real estate agent cannot insist on showing a seller's property to prospective buyers at any time but must respect the seller's wishes. The seller, on the other hand, should comply with reasonable requests to show the property. The agent must make full disclosure of all material facts concerning the transaction to the principal. The agent makes an accounting to the principal of their details of the transaction. This is a sensitive area for a real estate broker representing the seller in a transaction. A listing agent who brings a buyer to a seller should have qualified the buyer financially and discussed the buyer's purpose in buying real estate. Even if the listing agent legally represents only the seller, the agent inevitably is made aware of information that is useful to the seller. For example, the agent may have learned that the buyer is an out-of-state transferee with only a limited time in which to find a house. In such a case, the seller may have a stronger bargaining position. By law, the agent must disclose such information to the client. The seller must. Real estate licensees walk a fine line in balancing their obligations to their principal against their desire to gain the confidence of the person they want to bring to a successful transaction. The agent also must disclose to the principal any possible conflict of interest, such as dual representation. The agent must disclose to the principal any relationship. The real estate agent owes the principal the following duties of a fiduciary and OLD: A. Obedience, A. Loyalty, A. Disclosure, A. Confidentiality, A. Accounting, A. Reasonable care and skill. California _E_ principles _10E_ book. 159 the 23rd of May 2017 2:27 and 9 seconds p.m. 160 California Real Estate Principles 10th edition. The agent has to another party to the transaction, even if the agent or other party will derive no benefit from the relationship. At times, Even the appearance of impropriety is sufficient to require the agent to act. Of course, the agent can make no secret profit in a transaction. For example, Keysafe Realty has listed the Ray house for sale. Mabel Perkins, an aunt of the broker who owns Keysafe Realty, wants to make an offer on their Ray house. Can Keysafe take the offer to the res? Yes, but the relationship of Mabel Perkins to the broker must be disclosed to the sellers first. Regardless of the terms of the offer, the agent owes the principal the duty of reasonable care and skill in carrying out the tasks dictated by the agency agreement. This is true even if the relationship is gratuitous, one in which the agent receives no compensation after the agent has performed services on behalf of the principal, whether or not for compensation. The agent owes the principal the duties of a fiduciary. The agent's primary goal in a real estate listing agreement is to find a ready, willing, and able buyer for the property being offered for sale. When the agent has secured an offer that is at the seller's original price and terms, and if the buyer has the cash necessary to complete the purchase or the buyer can qualify for financing by a closing date within the seller's time frame, the agent's part of the agreement has been completed. If the prospective buyer's offer, suggested terms, or both are different from the owner's original stipulation, the owner can accept the different terms or make a counter-offer. When an agreement is reached, the licensee's contractual obligations have been met. For example, Sally and Tom Benson have listed their house at Lake Shastina for sale with broker Luis. The asking price is $165,000. And the listing is for 3 months. Within 2 months, Luis procures an offer from Mary Ivers for $163,750. All other terms are as stipulated by the Bensons, and Luis has determined that Ivers should qualify for the necessary loan. The Bensons accept the offer, and the sale is carried out. Has Luis earned his commission? Yes, broker Luis has produced a ready, willing, and able buyer who made an offer that was acceptable to his clients. Duties of subagent to principal and agent. A subagent owes to the principal the same duties as the agent and also owes those duties to the agent. The agent bears the responsibility of taking reasonable steps to ensure that the subagent acts with the required loyalty and care. Otherwise, the agent may be liable for any improper act, or failure to act, of the subagent. If the subagency was authorized by the principal shares that liability. Duties of principal to agent. If the agent's contract obligations have been fulfilled, the agent is entitled to the agreed-on compensation. The agent must be the procuring cause of the sale. The agent's job is to find a ready, willing, and able buyer. California_E_principals_10E_book.int 160 May 2017 2:27:09 p.m. Unit 6. The Law of Agency 161. Lease, rental, or other transaction. In other words, the agent must be the person who initiated the contact that brought the third party to the principal. In a listing for sale, the seller usually agrees to pay the broker a commission that is a percentage of the actual sales price. In a lease or rental agreement, the agent's compensation may be a percentage of the lease or rental value, or a flat fee. When is a commission earned? In a real estate listing agreement, the commission is earned when the real estate broker finds a buyer who is ready, willing, and able to purchase the subject property on the seller's original terms, or when the seller accepts a purchase offer at an agreed-on price, terms, or both. The principal can revoke the agency agreement but is liable for the expenses their agent has incurred and may be liable for the full amount of the agent's commission. In an open listing, if the seller accepts an offer that was not secured by their listing broker, the seller need not compensate the listing broker. If more than one acceptable buyer is brought to the seller, the listing broker will receive a commission only if his buyer is the first in time. For example, Keysafe Realty has an open listing agreement with the Carters. Keysafe brings to the Carters a buyer who will pay their asking price and is otherwise qualified financially. While the Carters are considering the offer, a good friend offers to buy their property for $3,000 less than the asking price. Because they will come out ahead if they do not have to pay a sales commission, the Carters accept the offer. Do the Carters owe the Keysafe broker a commission? Yes, because the first acceptable offer came through Keysafe Realty. If the offer through Keysafe was not at the seller's original terms, they would be free to accept their friend's offer without obligation to pay a sales commission, with the protection offered by an exclusive authorization and right to sell listing agreement. The listing broker will receive a commission regardless of who produces the buyer. A rare exception to this general rule may occur if the seller identifies a prospective buyer in the listing agreement as someone to whom the property may be sold without payment of compensation to the broker, and that person buys the property. If a different broker sells the property, the listing broker and selling broker usually share the commission according to the terms of the purchase agreement. Their commission usually is paid through escrow, an efficient and usually the safest way to distribute the commission proceeds. A principal owes an agent a duty of care in that the principal may not interfere with the agent's prospective economic advantage. This legal term means that the principal may not sabotage the agent's business. If a seller rejects a buyer brought by a broker, the seller may not turn around and make her own deal with that buyer, even if the broker and seller have an open listing agreement. If the broker is the procuring cause of a transaction, the broker has earned the agreed-on compensation. California_E_Principles_10E_book.int 161 May 2017 2:27:09 p.m. 162 California Real Estate Principles 10th edition. Duties to third persons. A real estate agent owes to a third person a duty of full disclosure of material facts that the agent knows or should have known regarding the property that is the subject matter of their dealings. The agent bears this responsibility independent of any instruction received from the property owner. If the property owner tells the agent not to reveal certain defects, such as termite damage, the agent must inform the principal that the agent cannot hide such information. To do otherwise would make the agent liable for money damages and place the agent's license in jeopardy. Material facts. A material fact can be anything that would affect the value or desirability of the subject property. Because this is such a broad definition, the legislature and courts have created their own interpretations of just what the prospective purchaser needs to know. Conspicuous physical defects must be revealed, certainly, but other factors may not be as easy to understand. It is not necessary, for instance, to reveal a death on the premises that occurred more than 3 years before an offer to purchase or lease is made. Nevertheless, the agent handling such a property may not make a misrepresentation if asked a direct question by the buyer. But the agent need not reveal that an occupant of the property was afflicted with, or died from, acquired immunodeficiency syndrome, AIDS. This provision appears in Civil Code Section 1710.2. Easton v. Strasburger. The decision in the California case of Easton v. Strasburger, 1984, expanded the broker's duty of disclosure to third persons. The court held that a real estate broker has an affirmative duty to conduct a reasonably competent and diligent inspection of residential property and to disclose to prospective purchasers all facts revealed by the investigation that materially affect the value or desirability of the property. This duty was subsequently recognized by the California legislature and made a part of the Civil Code, starting at Section 2079. It applies to residential property of 1 to 4 units. The Easton case involved a house built on landfill. That fact, and the fact that one of the broker's agents noticed an uneven floor, should have acted as red flags warranting further investigation and disclosure to the buyer. If there is a substantial property defect the agent could have discovered by a thorough inspection of the property. Even if the agent failed to notice the defect, the agent may be liable to a buyer for any resulting damages. Easton renewed interest not only in the broker's duties to prospective purchasers of residential property but also in the seller's duties to prospective purchasers. The seller must disclose any material fact known to the seller that affects the value or desirability of the property, including defects that could not be discovered from casual observation of the property. In addition, every seller of a residential property of 1 to 4 dwelling units must disclose to a potential buyer whether, during the course of the seller's ownership, or through previous knowledge, any structural additions or alterations were made to the property, and whether they were made with or without benefit of an appropriate permit. California_E_Principles_10E_book.int 162 May 2017 2:27 and 9 seconds p.m. Unit 6 The Law of Agency 163 The seller of residential property of 1 to 4 units must provide the buyer with a written real estate transfer disclosure statement that details the mechanical and structural conditions of the property in a form specified by law. The disclosure requirements are subject to change. Use of a form such as that prepared by the California Association of Realtors A registered, shown in Figure 6.6, is the best way for the seller and broker to be sure that the buyer is fully informed of the property's condition and that all legal requirements are met. The agent visual inspection disclosure form that is shown in Figure 14.7 in Unit 14 was prepared by the California Association of Realtors A registered to help the agent clarify the limitations on their inspection that the agent performs. Seller disclosure is also required in a sale of a used manufactured home or mobile home if the home is classified as personal property. Wording of the disclosure form is provided in Civil Code 1102.6d. Environmental disclosures, such as the possible presence of lead-based paint, are discussed in Unit 14. Other duties as in dealing with the principal, a real estate agent may not make a secret profit in dealing with a third party to a transaction. To do so would make the agent liable to the third party buyer or lessee. Exaggerating the attributes or benefits of property may subject a real estate licensee to liability if persons with whom the licensee deals accept the statements as accurate. Current concern for truth in advertising has made unacceptable what once may have been considered acceptable distortions of the literal truth. The best school district in the state should be exactly that by some objective standard, such as student test scores, or that representation should not be made. An agent is allowed to express an opinion, of course, but the opinion should neither be presented as fact nor misrepresent the facts. An agent is liable to third persons for any tort, physical injury or property damage, or other act, such as a fraudulent misrepresentation, that the agent performs. The agent also is liable for torts or other acts committed by the principal in which the agent acquiesces, whether the agent does so by act or by omission. The principal is liable for his own acts, acts of an agent or a sub-agent that were performed on the principal's behalf, and torts committed by an agent who is an employee, not an independent contractor, acting in the scope of the employment. For example, real estate broker Louise hires Sally and agrees to pay her a salary as well as a commission on sales she makes. When showing a house, Sally carelessly neglects to lock the back door. Before the owner returns, someone enters the house and steals a video game player. Is broker Louise liable for their owner's loss? Yes, because Sally was acting within the scope of her employment while showing the house. 164 California Real Estate Principles 10th edition Figure 6.6, Real Estate Transfer Disclosure Statement. Sample CALIFORNIA Association of Realtors A registered Real Estate Transfer Disclosure Statement, California Civil Code A Section 1102, ET Sec. CAR. Form TDS, Revised 414. Real Estate Transfer Disclosure Statement, TDS. Page 1 of 3. TDS Revised 414, page 1 of 3, print date copyright 2014, California Association of Realtors A registered, Incorporated. Reviewed by _date _ This disclosure statement concerns the real property situated in the city of _, county of _, state of California, described as _. This statement is a disclosure of the condition of the above described property in compliance with Section 1102 of the Civil Code as of date. It is not a warranty of any kind by the sellers or any agents representing any principals in this transaction, and is not a substitute for any inspections or warranties the principals may wish to obtain. Coordination with other disclosure forms. This real estate transfer disclosure statement is made pursuant to Section 1102 of the Civil Code. Other statutes require disclosures, depending upon the details of the particular real estate transaction, for example, special study zone and purchase money liens on residential property. Substituted disclosures. The following disclosures and other disclosures required by law, including the natural hazard disclosure. Report, statement that may include airport annoyances, earthquake, fire, flood, or special assessment information, have or will be made in connection with this real estate transfer, and are intended to satisfy the disclosure obligations on this form, where the subject matter is the same. Inspection reports completed pursuant to the contract of sale or receipt for deposit. Additional inspection reports or disclosures, __2. Seller's information. The seller discloses the following information with the knowledge that even though this is not a warranty, prospective buyers may rely on this information in deciding whether and on what terms to purchase the subject property. Seller hereby authorizes any agents representing any principals in this transaction to provide a copy of this statement to any person or entity in connection with any actual or anticipated sale of the property. The following are representations made by the sellers and are not the representations of the agents, if any. This information is a disclosure and is not intended to be part of any contract between the buyer and seller. Seller is not occupying the property. A. The subject property has the items checked below: exhaust fans in _220 volt wiring in _fireplaces in _gas starter _roofs, type, _age, approximately, other, to the best of your seller's knowledge, any of the above that are not in operating condition? Yes number. If yes, then describe. Attach additional sheets if necessary. See note on page 2. Range oven, microwave, dishwasher, trash compactor, garbage disposal, washer, dryer, hookups, rain gutters, burglar alarms, carbon monoxide devices, smoke detectors, fire alarm, TV antenna, satellite dish, intercom, central heating, central air conditioning, evaporator, coolers, wall, window air conditioning, sprinklers, public sewer system, septic tank, sump pump, water softener, patio, decking, built-in barbecue, gazebo, security gates, garage, attached not attached, carport, automatic garage door openers, number, remote controls, sauna, hot tub / spa, locking, safety cover, pool, child resistant barrier pool, spa heater, gas, solar electric water heater, gas, solar electric water supply, city well, private utility or other gas supply, utility bottled, tank, window screens, window security bars, quick release mechanism on bedroom windows, water conserving plumbing fixtures, buyer's initials, seller's initials, source, reprinted with permission, California Association of Realtors, a registered endorsement not implied, California _E principals _10E book.int 164 the 23rd of May 2017 2:27 and 13 seconds p.m. Unit 6 The Law of Agency 165 Figure 6.6 Real Estate Transfer Disclosure Statement Continued. Sample. Real Estate Transfer Disclosure Statement, TDS page 2 of 3. B. Are you, seller, aware of any significant defects, malfunctions in any of the following? Yes number. If yes, check appropriate spaces below. Interior walls, ceilings, floors, exterior walls, insulation, roofs, windows, doors, foundation slabs, driveways, sidewalks, walls, fences, electrical systems, plumbing / sewers / septics, other structural components. Describe, if any of the above is checked, explain. Attach additional sheets if necessary. Installation of a listed appliance, device, or amenity is not a precondition of sale or transfer of the dwelling. The carbon monoxide device, garage door opener, or child-resistant pool barrier may not be in compliance with the safety standards relating to, respectively, Carbon monoxide device standards of Chapter 8, commencing with Section 13260, of Part 2 of Division 12 of Automatic Reversing Device Standards of Chapter 12.5, commencing with Section 19890, of Part 3 of Division 13 of, or the Pool Safety Standards of Article 2.5, commencing with Section 115920, of Chapter 5 of Part 10 of Division 104 of the Health and Safety Code. Window security bars may not have quick-release mechanisms in compliance with the 1995 edition of the California Building Standards Code. Section 1101.4 of the Civil Code requires all single-family residences built on or before January 1, 1994, to be equipped with water-conserving plumbing fixtures after January 1, 2017. Additionally, on and after January 1, 2014, a single-family residence built on or before January 1, 1994, that is altered or improved is required to be equipped with water-conserving plumbing fixtures as a condition of final approval. Fixtures in this dwelling may not comply with Section 1101.4 of the Civil Code. C. Are you, seller, aware of any of the following? 1. Substances, materials, or products which may be an environmental hazard such as, but not limited to, asbestos, formaldehyde, radon gas, lead-based paint, mold, fuel or chemical storage tanks, and contaminated soil or water on the subject property. Yes, no. 2. Features of the property shared in common with adjoining landowners, such as walls, fences, and driveways, whose use or responsibility for maintenance may have an effect on the subject property. Yes, no. 3. Any encroachments, easements or similar matters that may affect your interest in the subject property. Yes, no. 4. Room additions, structural modifications, or other alterations or repairs made without necessary permits. Yes, no. 5. Room additions, structural modifications, or other alterations or repairs not in compliance with building codes. Yes, no. 6. Fill, compacted or otherwise, on the property or any portion thereof. Yes, no. 7. Any settling from any cause, or slippage, sliding, or other soil problems. Yes, no. 8. Flooding, drainage or grading problems. Yes, no. 9. Major damage to the property or any of the structures from fire, earthquake, floods, or landslides. Yes, no. 10. Any zoning violations, non-conforming uses, violations of setback requirements. Yes, no. 11. Neighborhood noise problems or other nuisances. Yes, no. 12. CCRs or other deed restrictions or obligations. Yes, no. 13. Homeowners association which has any authority over the subject property. Yes, no. 14. Any common area, facilities such as pools, tennis courts, walkways, or other areas co-owned in undivided interest with others. Yes, no. 15. Any notices of abatement or citations against the property. Yes, no. 16. Any lawsuits by or against the seller threatening to or affecting this real property, claims for damages by the seller pursuant to Section 910 or 914 threatening to or affecting this real property, claims for breach of warranty pursuant to Section 900 threatening to or affecting this real property, or claims for breach of an enhanced protection agreement pursuant to Section 903 threatening to or affecting this real property, including any lawsuits or claims for damages pursuant to Section 910 or 914 alleging a defect or deficiency in this real property or common areas, facilities such as pools, tennis courts, walkways, or other areas co-owned in undivided interest with others. Yes, no. If the answer to any of these is yes, explain. Attach additional sheets if necessary. _______D. 1. The seller certifies that the property, as of the close of escrow, will be in compliance with Section 13113.8 of the Health and Safety Code by having operable smoke detectors which are approved, listed, and installed in accordance with the state fire marshal's regulations and applicable local standards. 2. The seller certifies that the property, as of the close of escrow, will be in compliance with Section 19211 of the Health and Safety Code by having the water heater tanks braced, anchored, or strapped in place in accordance with applicable law. TDS Revised 414, page 2 of 3, reviewed by _date _property address, _date : buyer's initials, seller's initials, source, reprinted with permission, California Association of Realtors A registered. Endorsement not implied. California _E principles _10E book.int 165 the 23rd of May 2017 2:27 and 13 seconds p.m. 166 California Real Estate Principles 10th edition figure 6.6 Real Estate Transfer Disclosure Statement. Continued. Sample. Real Estate Transfer Disclosure Statement, TDS page 3 of 3. Seller certifies that the information herein is true and correct to the best of the seller's knowledge as of the date signed by the seller. Seller _date seller _date 3. Agent's inspection disclosure. To be completed only if the seller is represented by an agent in this transaction. The undersigned, based on the above inquiry of the sellers as to the condition of the property and based on a reasonably competent and diligent visual inspection of the accessible areas of the property in conjunction with that inquiry, states the following. See attached agent. The visual inspection disclosure, AVID form. Agent notes no items for disclosure. Agent notes the following items, agent, broker representing seller, by date please print, associate licensee or broker signature for agent's inspection disclosure. To be completed only if the agent who has obtained the offer is other than the agent above. The undersigned, based on a reasonably competent and diligent visual inspection of the accessible areas of the property, states the following. See attached agent. The visual inspection disclosure, AVID form. Agent notes no items for disclosure. Agent notes the following items, agent, broker obtaining the offer, by date please print, associate licensee or broker signature. V. Buyers and sellers may wish to obtain professional advice and or inspections of the property and to provide for appropriate provisions in a contract between buyer and sellers with respect to any advice/inspections/defects. We acknowledge receipt of a copy of this statement. Seller _date buyer date seller _date buyer date agent, broker representing seller, by date please print, associate licensee or broker signature. Agent, broker obtaining the offer, by date please print, associate licensee or broker signature. Section 1102.3 of the Civil Code provides a buyer with the right to rescind a purchase contract for at least 3 days after the delivery of this disclosure if delivery occurs after the signing of an offer to purchase. If you wish to rescind the contract, you must act within the prescribed period. A real estate broker is qualified to advise on real estate. If you desire legal advice, consult your attorney. TDS Revised 414, page 3 of 3, reviewed by _date _ copyright 2014, California Association of Realtors A registered, Incorporated. This form has been approved by the California Association of Realtors A registered, CAR. No representation is made as to the legal validity or accuracy of any provision in any specific transaction. A real estate broker is the person qualified to advise on real estate transactions. If you desire legal or tax advice, consult an appropriate professional. Published and distributed by Real Estate Business Services, Incorporated, a subsidiary of the California Association of Realtors A registered, 525 South Virgil Avenue, Los Angeles, California 90020, property address, _date : source, reprinted with permission, California Association of Realtors A registered. Endorsement not implied. California _E principles _10E book.int 166 the 23rd of May 2017 2:27 and 14 seconds p.m. Unit 6 The Law of Agency 167. Recovery account. The responsibilities of real estate licensees to their clients and customers are taken seriously by the California legislature. A recovery account has been established to help compensate victims of fraud, misrepresentation, deceit, or conversion, their legal term for theft, of trust funds when they cannot collect a court-ordered judgment against a real estate licensee. The recovery account is funded by 5% of all real estate license fees collected. The amount paid out is limited to $50,000 per transaction and $250,000 per licensee, regardless of the number of victims. If a recovery is allowed against a licensee, the real estate license of that person is automatically suspended. Reinstatement cannot be considered until the licensee has fully reimbursed the fund for the amount paid out plus interest. Exercise 6 Broker Cindy Carroll of ABC Realty would like to list the Meyer estate. She offers to handle the sale at a commission of 5% of the selling price. Meyer, a widow's, signs a listing agreement with Carroll. Carroll discusses the Meyer estate with an investor she knows. She agrees to bring the investor's offer to Meyer and, if the offer is accepted, to represent the investor when he resells the property, which will take place immediately after the first sale. The investor offers somewhat less than the asking price, but Carroll persuades Meyer to accept the offer. A few weeks after the sale, Carroll sells the property for the investor, who makes a 20% profit on the transaction. She earns 2 commissions. Comment on Broker Carroll's activities. Termination of an agency. The California Civil Code lists the ways in which an agency relationship may be terminated. They are summarized in the box below. Ways to terminate an agency: A. Fulfillment of the agency agreement. A. Expiration of the term of the agreement. A. Destruction of the property. A. Death of either the principal or agent. A. Incapacity of the agent to act as an agent, or incapacity of the principal to enter into a contract. A. Agreement of the principal and agent. A. By operation of law, as in a bankruptcy, the principal or agent always has the power to terminate the agency unilaterally, without the other person's consent, in writing. But the person who terminates the agency may be liable for damages to the other party. An early cancellation of California_E_principles_10E_book.int 167 the 23rd of May 2017 2:27 and 14 seconds p.m. 168 California Real Estate Principles 10th edition. A listing agreement by a seller is an example of a situation in which the seller may be liable to the listing broker for expenses or a commission. Notice of termination must be given to third parties with whom the principal and agent are dealing. For example, Sarah and Sam Schuster decided to move from Laguna Beach to Boise and listed their home for sale with broker Bonita Fish. After an extended vacation in Boise, the Schusters decided to stay in Laguna Beach and notified Fish that they were taking their house off the market. Can they cancel the listing agreement? Yes. The Schusters can unilaterally cancel the listing agreement. Broker Fish must decide whether she wants to charge the Schusters for any expenses she incurred in marketing their property. If Fish had already found a ready, willing, and able buyer for the Schuster house, she could also insist on payment of her commission on the transaction.
Perfect.